Okay.
Yep, go ahead.
All right. So, well, we're off we're off and running on a good start this morning. And so hello, thank you for your patience with us this morning. And, what can I say? Technology. And thanks for your forbearance and while we get ourselves together a little bit here. So welcome to our virtual new directors training. Technically, it's supposed to be new directors training, but we did open it up to all directors. So there are many on you here this morning who are new, and there's many who have had a lot of experience but just need a refresher. And if that's the case, then this is the day for you. So before I introduce our new state librarian, I just want to let you know that a little bit about the day. This is going to be a two-part session today until about 1 or 1:30, and then next week on February 24th. So today we're going to have a welcome from the state librarian, and you're going to meet our staff. And also we're going to have a talk on library law by Michael Cerrone, as well as purchasing. We'll have a couple of breaks in there, and then we'll have Pat Tumulty and Pat Pavlak come on to do a program on working with trustees. And I'll sort of be hosting that along the way and letting you know when the breaks are. So again, thanks for joining us this morning. And right now I would like to introduce you to our new state librarian, Jennifer Nelson, who is here from Minnesota, but is now a New Jersey girl. So welcome, Jen. And she would just like to introduce herself and say hello. So good morning.
Good morning. I'm pleased to be here. I'm excited to be in New Jersey and starting this new adventure with all of you. I feel comfortable with new directors, of course, because I'm new walking into this role here. I have an extensive background working particularly in public libraries and project development. So my major message that I would like to send out this morning is that my door is open. My email address is jnelson@njstatelib.org, and my cell phone is 612-819-6453, and I would love to hear from you. I'm looking forward to coming out and visiting, getting to know folks, and I really want to get a pulse of what's happening, and I think y'all are the best people to get me there. And I think that about sums it up for the morning. Thank you, Michelle.
Thank you, Jen. Have a good rest of the day. Thanks for joining us this morning. And I know that you'll be very involved in the community and get to know everybody throughout the state as your time goes on here. So thanks again for joining us. Right now, I'm going to bring on the team from the New Jersey State Library. They are the directors of many of our departments, and they're going to take just about 3 minutes or so to introduce themselves. And I guess I'm going to start with me. I'm Michelle Stricker, and I am the Deputy State Librarian for Lifelong Learning. And really what that unit provides, or our unit provides, are consultant services and technical assistance that's going to help create and improve library and literacy services in New Jersey. We are the continuing education unit. We administer grants to public libraries in the way of, IMLS grants that we would receive. And we have a number of people in the department, and we focus on a number of different things. And there's no doubt many of you know us already. So I will do, for example, trustee and library director training, new and experienced. I also do strategic planning. Disaster preparedness. I work a lot on community resiliency and preservation. And then I'm also involved with all of our state cultural organizations in the New Jersey Cultural Alliance for Response that is now going on its 10th year now. I am joined in the department by Andrea Lewandowski, who is our business workforce development and technology person. She's doing a lot of work now with workforce development with the Heldrich Center, and she's puts on a lot of great programs. We also have Mimi Lee, who is our diversity and literacy consultant. And we hope you are joining us for Mimi's Tea Talks on equity and diversity. She has already done her second one, and they are, great. And she does a lot of other programming that has to do with literacy, like the Literacy Boot Camp. So you can check out her programming. And last but not least is Sharon Rollins, who is our youth service specialist, who I think probably is the most famous person in our department. And, she does works with booklets and resources and grant opportunities and a lot of other topics that are of interest to youth services and librarians around the state. You'll find all of our emails on the on our website under staff, and you can contact us at any time. And please be sure to check our continuing education page on the website. There's a tab right at the top, and you can see all of the upcoming events that we're offering. So that's a little bit about the Lifelong Learning Department that's under the umbrella of library development. And I think at this point, I would like to bring on the my counter point to lifelong learning, and that's Kathleen Moeller-Pfeiffer, who is the Deputy State Librarian for Library Support Services, and she can tell you about sort of the other side of library development. So Kathleen, if you're here, I'm going to turn that over to you.
I'm here, and hopefully I can be heard.
You can.
Thank you, Michelle.
But not
the
seen.
Library Support Services Bureau at the State Library has an interesting array of projects that we work on for the New Jersey Public Library community. The LSS staff oversees the Library Services and Technology Act funding in New Jersey. These funds pay for the services of the Talking Book and Braille Center, e-resources, staff who work on statewide activities such as Jersey Connect, and new services such as Project Edge in 2020. The staff also convenes the Library Network Review Board and the Library Services and Technology Act Advisory Council, usually twice annually. Library law is handled by one of the specialists on this staff, Bob Keith, and he also handles statistics and the very important per capita state aid. The Jersey County Interlibrary Loan System in this bureau is managed by Casey Confoy, with support for questions on the system, as well as sending requests out of state to be filled when necessary. The State Library's grant manager, Eileen Morales, is also an LSS staff member. The person in this position searches for grants, both for the state library and libraries in the state, as well as conducts or sponsors grant writing workshops. And finally, if you have signed up for Zoom or other CARES Act products through the state library, our program assistant, Sahara Dampier, has been our point person on assisting you with that. So thank you all for attending today, and please do get in touch with me. As Michelle said, we have a page on the State Library's website that will give all the contact information that you need for us, email, telephone numbers, and what we do. And I'll just end by saying I'm also involved in the Library Construction Bond Act. I'm sure many of you are very interested in that, and we're getting ready to kick off the second cycle of that in the next week or two. Thank you.
Thank you, Kathleen. I think I'll turn it over next to Margaret Nizolik, the Deputy State Librarian for the State Library Information Center.
Good morning, everyone. The Information Center is the research library component of the State Library. We provide direct library services to patrons, just as you do in your libraries. We trace our official beginning back to 1796, when the library was formed to serve the needs of the legislature. Eventually, the judiciary and the executive branch of state government were included, and then over time, the mission expanded to also provide services to libraries, researchers, and the public. And since our affiliation in 1996 with Thomas Edison State University, we also provide library services to their staff, students, and mentors. So over the last 225 years, approximately, we've developed a number of special collections, and I want to share very quickly 6 of them with you. We're one of 4 comprehensive law collections in New Jersey. The other 3 are located in the law schools. You can refer people to our law library, but at this point, email is the method of contact while the building is closed to the public. And I will give you that address a little bit later on. So our law librarians provide guidance in the use of legal materials. They do not provide legal advice or analysis. One of the special things that they do is to compile New Jersey legislative histories, which are very important for judges and attorneys because they shed light on the intent behind the law. We have been a selective U.S. document depository since 1895. We select in areas of interest to state government. So we have a vast collection with a great depth of historical coverage. We are the depository for all official publications of New Jersey state government that are produced for public dissemination. So that includes things like reports, public hearings, annual reports, newsletters, maps, all kinds of things. We have over 48,000 items in the New Jersey State Publications Digital Library. That's our institutional repository. It includes born digital documents and print documents that have been scanned by our staff. And we have a very robust scanning production line going at this point. And those documents were critical to us in the early months of the pandemic to be able to provide the information that state government needed while they were dealing with funding issues, constitutional issues, and things of that sort. You know, we had documents back to like the 1844 Constitution and all kinds of other things that were at our fingertips, even though we weren't in the building. We have a large Jerseyana collection of books on a variety of New Jersey topics. These are things that are not published by state government. We also have atlases and historical maps. Our genealogy collection may be of particular interest to your patrons who are researching their family history, because we've noticed a lot of people are doing that while they're at home. The emphasis of our collection is on New Jersey. It includes local and county histories, city directories, and published genealogies and indexes, among other things. Last collection I want to mention, special collection, is the Funding Information Center. We have directories, books, and databases that focus on grant makers and grants that have been awarded. We offer classes on proposal writing and finding grants. And a special note, as a Funding Information Network partner with Candid, that was formerly the Foundation Center, we are temporarily able to provide remote access to the Foundation Directory Online Essential database during the pandemic. So if you're interested in that, all you have to do is go to the Funding Information Center collection page on our website, and there is a link to a form that you would submit, and then you'll get an email with access information. So you can learn much more about our resources and services by visiting the State Library website and selecting the Research Library. Please, please, please tell your reference librarians about us. I believe you received a brochure about SLIC in the information that you received, and they can reach us via email at refdesk@njstatelib.org or reflaw@njstatelib.org. Thanks.
Thanks, Margaret. Before we go next, I just want to call out Bob Keith, who's behind the scenes here working all the technology for us on this side. And I want to say that Bob is our director of library law and per capita state aid. So he's a very important person for you to get to know. He is the one that you would send any of your questions to if it has to do with the annual survey, and also any law questions. Really, he's the best person for you to contact. So thanks, Bob. Just wanted to acknowledge your role here at the State Library, and it's not just a Zoom master. Right now, I'm going to bring on Tiffany McClary, who's the Director of Marketing for New Jersey State Library. So, Tiffany?
Good morning, everyone. Yes, I'm Tiffany McClary, the Director of Communications, Marketing, and Outreach for the New Jersey State Library. So basically, the role of the Communications and Marketing Office at the State Library, we're here to support you. So we have several resources on the State Library website that you can access. If you, in the top navigation, if you go to Services for Libraries, there is a tab there for the Office of Communications. And if you click on that, you will be able to see all of our current offerings, which includes, we have an e-newsletter that goes out on a weekly basis. And we really try to keep all of that information fresh and current for you. We include grant opportunities and updates and events that are relevant to New Jersey libraries and that especially have a statewide impact. So you can subscribe to NJSL Direct directly through that webpage if you're not already subscribed, and I highly recommend it because that's our main touch point for communicating to the library community. We also have a marketing blog where right now you can actually browse through. There might honestly be hundreds of blog posts there. I haven't counted, but we have a lot of content on the website in the marketing blog on various marketing topics, social media, email marketing. Even now in the pandemic, we've put up content pertaining to using Zoom and hosting virtual events. So you can check that out. The content right now is kind of on pause. Our PR coordinator who was writing the blog actually has left the state library. So we have an open position. So once we get that filled, then we will resume with that content. But there's an archive of plenty of information that you can still comb through and get a lot out of. And then also on that page, you'll be able to find our branding guidelines. So for example, if you take part in a grant that is sponsored by the state library, there are some guidelines there for, how to properly use the logo and the proper attribution statements that you should be using in your press releases, so on and so forth. So check that webpage and you'll be able to find everything pertaining to the communications office. You'll be able to find my contact information along with my staff's contact information. And again, if you go to the top navigation on our website, click on Services for Libraries, and then if you scroll down, you'll see the State Library Office of Communications, Marketing, and Outreach. So hopefully you'll subscribe to our newsletter and we'll be in touch.
Thanks, Tiffany. And finally, I'd like to bring on Adam, who is the Deputy State Librarian over at our Talking Book and Braille Center.
Now you can hear me, Michelle?
I can hear you, Adam. Yep.
No?
Yes.
Okay, thank you. Okay, so the Talking Book and Braille Center is a division of the State Library that was established to serve New Jersey residents who, because of a visual or physical disability, cannot see the words in a book or hold the book in order to read. In order to do this, we entered into an agreement with the Library of Congress. And in this agreement, we function as their regional library for the state of New Jersey. In return, they've given us access to both their collection of books in audio and Braille format, as well as equipment to play back these books to individuals. We've also partnered with the New Jersey State Library, public libraries, in this effort because our opinion is that these public libraries are on the front line. Our patrons are your patrons. You know which people can use these services and can help them to do so. The books and magazines are in a password-protected web-based database called BARD, Braille and Audio Reading Services. There are over 18,000 issues of magazines and 120,000 issues of books and in Braille and audio format. The Library of Congress has been recording since the beginning of their program in 1933. They record about 2,000 books a year. Added to this collection are locally produced books by network libraries in Texas and Oklahoma. Recently, the U.S. Senate ratified an international treaty that now allows the Library of Congress to exchange books with other nations. So we're now finding books in German, in French, in BARD, as well as some other languages that are added almost on a daily basis. But most importantly, in recent years, the commercial publishers have offered their catalogs to the Library of Congress for this program. My notes here. And basically, there was an amendment in 1996 to the copyright law called the Chafee Amendment. And this allowed the Library of Congress to basically take any book and have it available for people who are in this program. Because of that, it's almost any book, anytime for individuals. So if a new book is published by Jane Patterson and it's posted that afternoon, anyone that wants that book can have it and have it for as long as they want. One of the other things with the program is that they've moved to mobile apps. So a lot of the people using this are on cell phones and iPads, both Android and Apple products. There's over 170,000 nationwide people who are actually accessing these books with their cell phones and iPads. The state library has also been working to authorize public libraries to be part of our program in a sense that they can download for themselves. So we've instructed 81 public libraries to actually function as us. So patrons can go into their library, ask for a book, the library can download the book and then give it to the individual. We also have 73 public libraries that have institutional accounts, know about our services, and are able to take and then tell people about them. The Newton Public Library, the Belmont Public Library just published a video or produced a video about services in connection with us. With 10% of New Jersey residents being impaired with a disability, and this is reported by the website monitored by Cornell University, the opportunity is here to better serve our patrons. So with that, please contact me if you're interested in becoming one of our institutional libraries to download. Thank you, Michelle.
Thank you, Adam. So that's all the staff that could join us this morning. And I want to let you know that everyone that spoke this morning is accessible via email. And please feel free to contact any of us if you have further questions. I mean, it was such a short introduction this morning. Just gave you a real broad overview of all the things that we do. And if you want to know more, that's why we're here. So please feel free to contact us at any time. At this point, I want to bring on Michael Cerrone. Michael Cerrone Esquire is going to do our library law program. I know many of you know Michael Cerrone because he's been doing this program for us for a number of years now, and it just gets better and better all the time. And so I want to let you know that if you have questions about anything, there will be time at the end for Q&A, but please put your questions in the Q&A box, not the chat box. Bob will be monitoring the Q&A, and when we get towards the end, we will ask those questions of Michael. So Michael, welcome this morning. I'm going to turn it over to you. I know that this is sort of the longest program with the densest content. So you're going to hear a lot this morning. Don't worry about taking it all in at once. You're going to have be able to link to this recording so that you could watch it again. And also, feel free to ask direct questions afterwards. Send any questioning to Bob. So Michael, welcome. Thanks for joining us again this morning, and glad to have you here.
Thanks, Michelle. And I'm happy to be here. Welcome, everybody. Hope everybody was able to get the right link and has joined us. So let me start with a disclaimer. Thanks to my, at the request of my malpractice carrier. The information I'm providing you today is for informational purposes only and is not to be considered legal advice. This seminar does not create an attorney-client relationship. You should contact your attorney to obtain advice with respect to any particular issue or problem. So let me just go through an outline of what we're going to try and cover here today. I'm going to briefly describe the different types of public libraries in New Jersey, most of which are municipal libraries. I know that we have a few county libraries on. We may have one or two association libraries on. I will talk about trustees of libraries, the oath of office that's required, attendance requirements, the trustee education requirement. I'll try and review laws that are specific to libraries, the organization of your board and their officers, the powers that the trustees have. I want to take a moment to discuss the autonomy that the board has and the role that the mayor has on libraries and municipal libraries and joint libraries. I'm going to discuss how libraries are funded, what you can use the money for, eligible versus ineligible costs. I'll discuss the excess funds statute and the Confidentiality of Library Records Act. Then we're going to move over to statutes that are applicable to all public entities. We'll discuss in some detail the Open Public Meetings Act. We'll have a discussion about personnel and civil service regulations, a small discussion about the Paid Sick Leave Act, FMLA and FLA in the Open Public Records Act. Then I'm going to conclude with a couple of practical matters involving insurance, policies, your friends of the library, the role of the director, and as Michelle said, we'll hopefully have time for Q&A. Put your questions in the chat, and I know that Bob and Michelle will collate them, try and make an orderly Q&A. So, as I said, there are three different types of public libraries: municipal or joint municipal libraries. These are formed by public referendum. They are only formed by a vote of the voters. The trustees on a municipal and joint municipal library are appointed by the mayor, or in a joint municipal library by the mayors of the joint municipal library. In addition, there are two ex officios. The county is formed by referendum, although if it's a small county, less than 150,000, it can be done by resolution of the freeholders. And there's another exception with regard to one other county library. The trustees, if you will, of a county library are actually called commissioners by the statute and are appointed by freeholders. And for those that don't know, freeholders are now called county commissioners, effective January 1. Finally, association libraries are not public in that they are not public entities. They are nonprofit corporations formed pursuant to the Nonprofit Corporation Act, and I've given you the site there. Membership of municipal and joint municipal libraries, both the mayor and the chief and the superintendent of schools are ex officio, meaning by virtue of their office, they're automatically members of the library board and have the power to vote. For municipal libraries, 5 to 7 citizens are appointed by the mayor to add to the mayor and superintendent as the board. In a joint municipal library, the mayor of each member municipality gets to appoint 3 citizens. Now, I underline the word citizens for a reason. Appointed trustees of municipal and joint municipal library boards must be citizens. However, not all trustees have to be residents of the municipality. Up to 4 on a municipal library, for example, have to be, 4 of them have to be residents, meaning that the 5th in a 5 appointee board could be from out of town. It's rare, but I've seen it happen. Appointed trustees cannot be employees of the municipality. The legal theory is called the doctrine of incompatibility of offices. There is the Attorney General opinion, which I've cited for you, and just bear that in mind. The County Library Commission, the commissioners, a majority of those must be residents of municipalities that support the county library. And unlike municipal libraries, there's no requirement in the statute that they be citizens. Association libraries, as I mentioned earlier, are formed pursuant to the Nonprofit Corporation Act. Under law, the mayor and council, the governing body of the town, can provide funding to the association library. According to the statute, the only string that the mayor and council can put on that municipal aid is the hours of operation. However, unlike a municipal library, where you have no guarantee of funding. And so, although the statute says that you have to be open for such reasonable hours as the mayor and council approve, in reality, they could attach other strings to your funding, or put another way, if they don't like what you're doing, they could withhold funding. Now, although association libraries are not public entities, they are, you are subject to the Confidentiality of Library Records Act. All libraries, no matter where they are, law libraries, corporate libraries, all are subject to that act. In addition, state laws such as the Open Public Records Act may apply. In fact, I really think the Open Public Records, the Open Public Meetings Act does apply to you since you're getting funding from the municipality. Others, like the local public contracts law, may apply. Now, for municipal libraries and joint municipal libraries, trustees are required to take an oath of office. It really is supposed to be done before you can vote. You should be sworn in as soon as you get your notice that you've been appointed. The normal process would be your municipal clerk contacts you, notifies you, typically in writing, that you've been appointed. Please come to my office so that you can swear your oath. It's a written oath, as I said, usually done by the municipal clerk, but legislation that now has got to be about 10 years old allows the president of a library board to administer the oath. So you should be prepared for that, directors. So if you have a trustee that shows up, you know, because you got copied on a letter that they've been appointed, but they never got down to the municipal clerk or they didn't know it. Have them sign the oath in front of the president, having the president acknowledge it. I would suggest you do 2 originals, file 1 with the municipal clerk, keep 1 for your records. Statute also has attendance requirements, again, only for municipal and joint municipal libraries. The statute says that if a trustee is absent for 8 consecutive weeks, or more likely 4 consecutive regular meetings, without an excused absence, the board is required to declare the office vacant and notify the mayor. Now, you have to check with your town to see if your mayor and council has adopted an ordinance that reduces the time from 6 consecutive weeks or 3 meetings. Now, the board has discretion to excuse absences, but the statute requires that you excuse for legitimate illness. What I've recommended for library boards is that at the beginning of the meeting, when attendance is called, if a trustee is absent, if that trustee has notified the president or the secretary of the board or the library director as to the reason why and wants to ask the board to excuse the absence, you should take a vote at that time to excuse the absence. It's within your discretion, as I said, the board, that is, not you as directors, but they must for legitimate illness. Many of you probably know this, but there is a trustee education requirement. The board as a whole has to accumulate 7 total hours of library-related education on an annual basis. That means 1 trustee could get 7 hours, 7 trustees could get 1 hour each, or some combination thereof. You'll know that this is necessary for part of your qualification for per capita state aid, and I highly suggest that you get trustees, remind trustees of any opportunities to get that education. So how is a municipal library board organized? The term of office for trustees is 5 years. Trustee terms are staggered. What does that mean? It means that every year, at least 1 trustee's term must come up for renewal. If you have 5 appointed members, 1 will come up each year. If you have more than 5 appointed members, you'll have multiple come up in some years, but at least 1 in all others. The terms are supposed to start at the same time of year. Many will be January 1. There are some that are July 1. I know of boards that are February 1. If any vacancies occur, and this is where problems occur with the stagger, vacancies are to be filled only for the remainder of the term. So if Trustee Smith was appointed to a 5-year term, and after 3 years decide they've retired and moved to Florida, there's 2 years remaining on Trustee Smith's term. If Trustee Jones gets appointed to fill that vacancy, there's 2 years left before Trustee Jones is up for renewal. um, officers of the library. By statute, municipal libraries are supposed to have 3 trustees: the president, the treasurer, and secretary. The statute calls for a 1-year term, or until their successor is elected if it goes beyond the 1 year. The statute doesn't describe any duties of any of the offices. But if the board adopts bylaws, I would highly suggest that the bylaws spell out those duties. With regard to the treasurer, statute requires that the treasurer be bonded. I recommend that in addition to the treasurer, number one, that you have any banking accounts. My slide says checking account, but any banking account require at least 2 signatures for signing a check or withdrawing. And that anybody who has signing authority be bonded or insured. Now, I mentioned bylaws a moment ago, and that you should list the officers and their responsibilities. Now, I find many boards like to add a vice president. But if you have 5 appointed trustees, typically the mayor and the superintendent are not going to be officers. That would mean out of the 5 appointees, 4 would be officers. And that to me is a bit top heavy. Usually the only responsibility of the vice president is to act in place of the president. My suggestion is that you put that responsibility on the treasurer and or the secretary when you describe the responsibilities. I suggest a committee structure. And I've given you some ideas as to what committees might be formed. You may have others, or you may describe them differently. There's some a value to that, and when I get into the Open Public Meetings Act, I think that'll become apparent. In addition, your bylaws should cite a parliamentary authority. The most common is Robert's Rules, and I've given you the wording there for how you should cite the Robert's Rules. Robert's Rules is a volume that is updated every 10 years. If I'm not mistaken, they've just updated the last year to the 13th edition, but don't cite to a numerical edition, cite to the current edition. So what are the powers of a library board? And this now is both municipal, joint municipal, and county libraries. They have the authority and the power to buy books and other related matter, to hire librarians and other necessary personnel, to fix the compensation of employees. Now, the statute says rent rooms or construct buildings. The intent of the statute is not you renting out your community room, but rather you renting rooms for library purposes. I have at least one library I can remember off the top of my head that actually leases space in a strip mall. So where there's a Stop and Shop and other stores, they have a branch library. The library board can adopt rules and regulations, and I'll talk about that more when we get to policies, and then a catch-all, do whatever is necessary to maintain the library. For me, this lends a lot of autonomy to the library board. What does that mean? It means the board runs the library, not the mayor, not the council. In fact, way back in 1959, the Attorney General of New Jersey issued the formal opinion, the site I've given you in the slide, that opines that the library statute excludes any interference by the mayor and council with the powers of the trustees. In that case, it was a personnel ordinance that the governing body had adopted that they were trying to impose on library employees. The Attorney General said, no, you can't do that. That's legal autonomy. That is, you have the right, the library has the right to govern itself. But because the library statute is not all-encompassing, that is, you can't strike a tax rate and raise the money you want. You can't go out and bond for capital improvements, for a new roof or an addition to the library, you need in some way to work with your mayor and council. And so from a political point of view, you don't quite have that full autonomy. So you're going to want to try and have good relations where you can with your mayor and council. In fact, the mayor, to me, is the linchpin between the library and the municipality. Yes, the mayor appoints the trustees, but he only has one vote. Trustees should think for themselves. He is not the CEO of the library. I've had one instance I can remember where the mayor was practically dictating to the director and the other trustees how things should be done. That's not the role of the mayor. Because terms are staggered, trustee terms are staggered. And because if there were to be a reorganization of the municipality and a new form of government adopted, all municipal boards get wiped out when that happens, but not a library board. To me, along with the staggered terms, that tells me that the design of the library statute is structured to minimize, not eliminate, but minimize political influence. Now, know that as the appointing authority, the mayor is going to try and influence other trustees. And you've got to try and encourage your trustees to remember they've taken an oath of office to fulfill their duties as trustees of the library, not as adjuncts of the mayor. Now, having said all that, the mayor sits on your board, and you really should try and cultivate a good relationship with the mayor and hope that the mayor becomes your advocate to the governing body so that you can hopefully get town services or some assistance with your capital needs so that, for example, they'll bond rather than have you having to pay out of your operating. So, funding. By statute, municipal and joint municipal libraries must receive 1/3 of a mil, that is 1/3 of a mil of equalized property valuation in the town. For the county, it's a minimum of 1/15 of a mil. The freeholders, Canal County commissioners, set the number. For municipalities and joint municipal libraries, your funding, that minimum 1/3 of a mil, appears as a separate line on the tax bill that the property owners get every year. As a result of that statute that struck that put the municipal library funding on the tax bill, that 1/3 of a mil is no longer subject to the town's budget cap of 2% currently. Now, the municipality can appropriate more money, but that extra money is subject to the town's budget cap. What does that mean? That means that if the town faces a budget crunch and needs to cut, they could cut the extra money to try and help them with their budget cap. They can't touch the 1/3 of a mil, but they could the extra money. Now, statute requires that the money that is appropriated to the library be paid quarterly to the library treasurer. State library regulations allow that money to be kept in a reserve account with the municipality and dispersed upon approval of library trustees. Now, this next point is somewhat important. Any prior year unexpended funds from that 1/3 mil funding have to be retained in a library controlled account dedicated for eligible purposes, and you can still access that money right away. There are some municipal CFOs that apply the statute that governs their municipal budget to yours that says, oh no, any money that's left over from the prior year has to sit dormant for a year before you get access to it. That's not the case. Now, recently, legislation was passed, thanks in large part to the efforts of NJLA, to allow the voters to change the minimum funding that is required under statute. It's commonly referred to as the Johnson legislation because Assemblyman Johnson from Bergen County was the main sponsor of the bill. The governing body of the municipality on their own, or if a petition signed by voters, has to submit to the voters a referendum to change the rate of funding. Now, there's a lot of politics that goes into that, and I'll try and get to that at the end of the slide. Any rate, if the voters adopt a new rate, that new rate will expire after 10 years or in a tax year after a new referendum is adopted establishing a new rate. The new rate is exempt from the 15% annual cap set forth in the statute. In the first year that the rate is in effect, the library is exempt from the excess funds statute. Now, the wording of the public question is set forth in the statute, as is the outline for the interpretive statement. Now, let me talk to you a minute about the politics of getting this done. My knowledge has only been 2 municipalities that have tried it. One failed, one it passed. If you can't convince the governing body to do it on its own and you have to go out and get a petition, it's a petition equal to 15% of the votes cast in the prior general election. So if you wanted to get the referendum on for this coming November 2021, that means you would need to get 15% of the votes cast in last November's presidential election. Every 4 years, without fail, the presidential election is the election with the highest turnout, and therefore you're going to have a far greater burden to get a petition signed by 15% of the votes that were cast in the last general election. But if you go back the year before to 2019, that was the year that at the head of the ticket was, in most places, the assembly. That is the lowest turnout election. That'll be very easy for you to get a petition signed. But of course, then your referendum is going to be on with the presidential election year, and your petition is going to be buried somewhere on the ballot, the bottom right-hand corner on the back page of the paper ballot, and you may get people that just forget to vote on it. You've got to plan out how much you want to raise that rate, because if you go for too much, that may be a surefire way to lose. But if you don't get enough, you may not get the bang for the buck you're looking for. Now, I've talked about source of your money. What can you spend the money on? The money raised by the taxation must only be used for eligible costs, which are costs related to the direct operation of the library. As I said before, the statute is not designed to fund capital costs. You don't have the right to change your tax rate unless you get the voters to do it, or to bond money for capital improvements. And so you see that among the ineligible costs, you cannot pay rent to the municipality and you cannot pay for debt service. So you can't go to the town and say, hey, we need a new roof or we want to do an addition. And the town says, great, we'll do it. And we're going to charge you the debt service. No, remind the town that your library is a municipal asset. And therefore, it's really incumbent upon them to maintain their asset. Now, you can use the mandatory funding for capital expenses only if you have a written capital plan that's been approved by your Board of Trustees. Now, excess fund statute. If you want to try and reserve money out of your operating budget, there is a way to do it, provided that you can maintain your normal operation and not scrimp on the service by reserving money. The excess fund statute requires the library to return a surplus in excess of 20% of last year's audited operating expenses. So, as an example, if last year's audited operating expenses were $100,000, you can hold up to $20,000 in surplus, in reserve, and not have that subject to the excess fund statute. But if you had $25,000 or $30,000 in unrestricted funds sitting in a bank account, anything over that 20% is supposed to be returned to the municipality, theoretically at least. Now, return of funds must be approved by the state librarian. The state library website has a package of materials, a full packet that has to be used and followed before a return can be approved. Now, any money that's been donated to the library and any money that you've previously restricted for capital are excluded from this calculation. That is, they're not subject to the excess fund statute. So how do you get to keep your money? I suggest a couple of things. One, get a separate bank account just for your restricted funds. All your donations should go into that bank account. Any money that you reserve for capital purposes should be transferred out of one account into that restricted account. Now, to get a capital plan that's going to hold some water, go out and hire an architect or an engineer to give you a 3 or 5 year capital plan. Have them go through the library. May you expect to need a new roof in the next 5 years, new HVAC system, carpeting, lighting, upgrade your restrooms, make things ADA compliant. Have them put that out in a timeline and get an estimate of cost. That will back up your desire to reserve money for capital purposes and may also help you if you have to go to the town and say, hey, we need you to bond for money. You're being responsible by hiring an architect and planning ahead. Whenever you want to restrict any of your operating money, I strongly suggest you adopt a resolution restricting the funds, either a paper resolution and or in your minutes showing that you restricted these funds, and then a resolution transferring that money to that restricted bank account, or that bank account for restricted funds, I should say. Now, if you have to return excess funds to the municipality, know that it can only be used for tax relief. They cannot take that excess money and hire an extra worker in City Hall, an extra fireman or policeman. We've had a lot of mayors come to them and say, listen, you got all this money. I have to pay cuts in the police department. I need that money to be able to fully fund the police department. Statute doesn't allow for that. So don't fall into that trap. So the Confidentiality of Library Records Act, library records that have the names of your patrons or any personally identifying details regarding users are confidential and cannot be disclosed unless they are necessary for the operation of the library, or the user requests that you disclose them, or you have a court order or court-issued subpoena to disclose that. The fact that people are trustees or employees of the library does not automatically make them entitled to library records. So, for example, if you send out emails or letters notifying people that their library book is past due and they need to return it, and they're incurring fines, whatever it might be, somebody in your circulation department that's responsible for that is entitled to access to that. Your reference librarian, if he or she is not supervising that circulation person, has no business getting that information, as an example. Now, I'm sure many of you, if not all of you, use patron emails to communicate to patrons. If it's to communicate them for something they've asked for, like, let me know when a book that I put on reserve comes in so I can come and get it, that's fine. But if it's to use the email for an email blast, a newsletter, or something like that, you should consider having a policy that either allows them to opt in to get the email or to opt out saying, I no longer want to receive it. And you should consider drafting and having a privacy policy in place. Okay, so those are statutes that are specific to libraries. Now we're going to get into a more broad area of statutes that are applicable to all public libraries, which include all public entities, I should say, which include libraries. The Open Public Meetings Act is something you have to work with every time your board meets. There's a public policy that the public has the right to adequate advance notice of those meetings and the right to attend those meetings. Your notice must give the date, time, and location of the meeting, and to the extent known, the agenda of the meeting. That notice has to be given at least 48 hours in advance. It has to be posted in a prominent location. It has to be delivered to at least 2 newspapers. Now, to give you an idea just how old the statute is, the statute talks about mailed, phoned, or hand-delivered, does not mention email. I know many newspapers now will only accept an email notice. So I'm sure that emailing is within the intent of the statute. Now, in lieu of noticing each month's regular meeting, at the annual meeting, that is the meeting when the board reorganizes, the board can adopt a resolution setting a schedule for the year. And if it provides notice of that schedule, as indicated, then you won't have to notice each individual meeting. Now, the notice for the annual meeting does not have to include the agenda, because obviously an agenda each month will change. So I would strongly urge that you do that. Now, we're in a public emergency, and there are some additions or changes to the requirement of the Open Public Meetings Act. So in addition to the normal notice, you must post your notice on your website. If the only notice you can provide is on your website, then the meeting is limited to matters necessary for the continued operation of the library related to the emergency declaration, or those decisions which must be made due to time constraints. Now, you must allow for public comment, and if you're using technology, that comment can be made live, that is through Zoom or WebEx or one of those, or you've got to give them the opportunity to send in an email or a written letter. In the last 2 cases, those comments would be read during the time for public comment. You can adopt a reasonable limit for the time of those comments, and I would suggest you go no more than 5 minutes per commenter. Now, because you're getting written comments, you may get duplicative comments that are sent in, and you can pass over those, but you must note that the comment that Mary Jones and Bill Smith agreed with Mike Cerrone as to the comment that the library should be open on weeknights, or you should have programming for senior citizens or something like that. You're supposed to adopt a resolution setting forth these procedures. If you're using a web-based technology such as Zoom, you also have to provide a telephone conference call-in for people, and you must have a provision that allows the chair or someone at the chair's direction, if you have an IT person, to mute the public so that you avoid the problems of Zoom bombing. Now, there may be a time when you have to have the board meet in an emergency, and you can't provide the 48-hour notice that is required by the statute. If that's the case, the board can meet, but the first thing the board has to do is adopt a resolution that's approved by at least 3/4 of the members attending, stating that the subject matter of the meeting was so urgent that a delay in the meeting to provide the adequate notice would result in substantial harm. An example might be you've got a problem with your boiler in this cold weather, and you need the board to meet to approve an emergent contract, okay? The meeting would be limited to just that matter. the emergent contract. You can't do anything else after saying, hey, listen, I've got everybody here. Let's talk while we've got everybody here. Let's talk about our plans for the new children's room or something like that. You can't do that. You're also required after the meeting to provide notice of the meeting, that the meeting was held. You have to do that as soon as possible. And that notice is going to mimic the notice you would have given beforehand. That is, when you met, you've got to give it to the newspapers, you've got to post it, you've got to give it to your municipal clerk or county clerk. Now, under the Open Public Meetings Act, the board is required to have a quorum to conduct business. That is a majority of the board. So if you have a 7-member board, you need at least 4 members present. Now, the Open Public Meetings Act does not apply to meetings of less than an effective majority of the board, meaning committees. And I'll touch on that more in a minute. Your board is required to keep minutes of its meetings. The minutes must contain the time, date, and place of the meeting, those members that are present, what subjects they considered, what actions were taken, and the vote of each member. Now, it does not require that you have a summary or a transcript of what each person said. One municipal clerk famously said, listen, I'm keeping minutes, not hours. It's just supposed to be a summary of what happened. It's not supposed to be a detailed historical document. Now, if your board wants that, you can do it, but it's not required. Now, any minutes of public sessions must be made promptly available to the public. There's a dicta in one case that suggests you don't even have to wait for them to be approved. But if your board meets on a regular basis, it's probably a better practice to wait until your board meets to review and approve the minutes. Now, you're also required, or your board is also required, to keep minutes of closed sessions. And there's rules with regard to when those minutes can or must be made public. But until those conditions apply, the minutes of a closed session, as you might expect, are kept confidential. Now, closed sessions. In order to go into a closed or executive session, the board is required to adopt a resolution. And the resolution must state the reason they're going into a closed session and the time and circumstances under which the minutes can be made public. Now, amongst the meeting matters that can be discussed in a closed session are personnel matters, litigation, and things covered by attorney-client privilege, and contract or collective bargaining negotiations. Now, the board cannot take any action in a closed session, but can have a straw vote. In other words, get a consensus or a sense as to what the board will do when it goes out in public to actually take the action. Now, under personnel matters, I've highlighted the Rice notice. Many years ago, there was a case, Rice versus Union County Regional Board of Education, in which the appellate division gave guidelines as to what has to be done with regard to personnel matters that are to be discussed by the board. If the board wants to discuss a personnel matter in closed session, it must notify the employee or employees affected that this discussion is going to be in closed session unless the employees request that the matter be discussed in public. Now, if all you're going to do is vote on a personnel matter, that is, your committee is making a recommendation and the board is absolutely confident they're not going to have any discussion, then you don't need to notify the employee. There's a recent Supreme Court case from New Jersey that said just that. However, my best advice to you is to always notice employees whenever a discussion might occur to avoid delays or, even worse, a lawsuit. Now, let's talk for a minute about email. You want to avoid violating the Open Public Meetings Act by having a meeting break out via email. If an email goes out to the full board and everybody is the addressee or is copied on it, in a public way, then they could start replying all and start discussing whatever's in that email or more. And that would be a violation of the law because they're discussing matters that are supposed to be open to the public. My suggestion is if you email your board, for example, many boards now send out their monthly packet via email to the board members. Put all the board members in the blind CC line, or there's a method under some software for an undisclosed recipients, which means that when you reply or reply all, those people don't get the email. Now understand there are penalties for violating the Open Public Meetings Act, chief of which is an injunction, a court order that would undo the action taken by the board. And there are civil penalties for people that knowingly violate the act, $100 for the first violation and $500 for subsequent violations. Okay. Let me segue to personnel matters. Many of you have personnel policies or an employee or personnel manual or employee handbook. Excuse me. That if you're going to have that, I strongly suggest you have a sexual harassment policy and an affirmative action policy that's prominent in the handbook. You should describe your work week, and that's important for libraries because your work week isn't like City Hall's, which is 8:30 to 4:30 Monday to Friday. You've got nights, you've got weekends. You should describe meal breaks. You should describe what vacation or sick leave your employees are entitled to, bereavement leave if you have it, and discipline procedures. And if you have a collective bargaining agreement with a union, make sure that what is in the handbook is consistent with what's in that agreement. Because if there's a discrepancy between the two, the bargaining agreement should apply, but if the handbook is more generous and you've been following the handbook, you may have a past precedent that now is going to change without your intent, the collective bargaining agreement. Now, if you are in a civil service town, your library employees are civil service. One of the few cases involving library law says just that. If the job description, job title, I should say, that you want to hire is in a classified position, then there has to be a list generated by civil service. Before the list is generated, you can hire somebody provisionally, and they could be in that position for a year or more before there is a call for a test, and you can make an appointment permanently. Once a person is appointed to the permanent title, there is a working test period of 3 months, during which time you're supposed to provide progress reports. If the employee is dismissed before the end of the working test period, the employee has the right to appeal, but that right is more limited than if they get through the working test period and they are now no longer probationary, but are permanent in title. Now, civil service sets forth the causes of discipline, and you see them here. I won't read them. You have them on the slide. For those of you that are not civil service, I would suggest that you follow these as the reasons for terminating an employee, even if you have an employee handbook that says all employees are at will. The reason why I say that is because if you get to a point where you terminate someone, and if that person you terminate is someone other than a white male of European extraction under the age of 40, that employee has a prima facie case for discrimination. What does that mean? That means they can file a case saying that you discriminated against them because of their gender, their religious belief, their race, their gender identity, etc. And the burden will be on you to prove that you had a valid reason. And so if you use this list, and you can document incompetency, an inability to perform duties, excessive absenteeism, conduct unbecoming a public employee, and you follow some level of progressive discipline, then you're going to be in far better shape. Under civil service, you're going to have to follow progressive discipline. That means that unless it's something where somebody gets arrested for something very serious and you have to suspend them right away, you are going to go through a series of oral warnings, written reprimands or censures, and then suspensions without pay, an employee improvement plan before you get to termination. So a couple of years ago, the legislature adopted and the governor signed into law the Paid Sick Leave Act. This allows employees the right to accrue up to 40 hours of earned sick leave per year at the rate of 1 hour for every 30 hours worked. You must provide employees with a notice of their rights under this act. And I've given you the URL for the poster that the Department of Labor in the state has come up with that you have to post and provide to the employees. Now, in the act, the definition of employer does not include a public employer that is required to provide sick leave to its employees. And it also says that an employee does not include an employee that's entitled to sick leave. Well, if you're a civil service library, you're required to give sick leave under the Civil Service Act, and therefore you're not subject to the Paid Sick Leave Act. If you're not civil service, you are subject to the Paid Sick Leave Act. Now, there are two acts that confuse the heck out of people, sometimes me included. They are the State Family Leave Act and the more popular or more well-known, I should say, Family and Medical Leave Act, FMLA. Public libraries, regardless of the number of employees, are covered employees as a public entity. Employees that may be entitled to this various leave must have worked at least 12 months for you, but it doesn't have to be 12 consecutive months. To qualify for family leave, FLA, they must have worked at least 1,000 hours in the 12 months prior to taking leave. For FMLA leave, it's 1,250 hours. Now, FLA leave is for the serious health condition of an immediate family member or the birth or adoption of a child. There, the leave has to be taken within 1 year of the birth or adoption. Now, the State Family Leave Act does not apply to the employee's own medical condition. That's where the FMLA adds something that applies to the health condition of the employee. Now, the amount of leave is different. 12 weeks, yes, for both, but for state FLA leave, they're entitled to 12 weeks in a 24-month period of time. For FMLA leave, it's 12 weeks in a 12-month period of time. Leave is job protected. That means that you have to return the employee to the same job or a similar job unless you have a valid economic reason for having eliminated the job. This leave can be taken in increments. FMLA leave, they're entitled to take it in increments. FLA leave, if you agree to allow them to take it. In either case, if it's intermittent leave, the employee has to schedule the leave to minimize the disruption for you as the employer. Typically, intermittent leave comes when somebody has to go to rehab, 2 or 3 days a week. You try and get them to schedule that rehab so that it has the minimum impact on you. Now, you can require your employees to take any paid leave concurrently with FLA or FMLA leave, meaning that they would be getting paid using their accrued sick leave or vacation leave. FLA and FMLA leave is unpaid leave that they're entitled to. And if you don't require them to concurrently exhaust paid leave, if they take paid leave and then at the end of exhausting that paid leave, say, okay, now I want to take my FLA or FMLA leave, you're going to have to give them that leave. Now, you have to keep the employee on health insurance during that time, even if they're not getting paid, but the employee is required to make their normal contributions for the cost of that. The Open Public Records Act does apply to libraries. a record, a government record is broadly defined. Personnel records are exempt. However, the statute requires that if asked, you have to disclose the employee's name, their job title, their position, their salary, and the length of service, but clearly not disciplinary records or anything else, medical records, things like that. Compliance for the Open Public Records Act, there's two venues, either the Government Records Council, which is a state agency, or the Superior Court of New Jersey. There are penalties for anyone who knowingly violates the law, and a successful requester, that is someone who makes a request for a public record and is denied and goes to the GRC or Superior Court and gets an order compelling the turnover of the records, that successful requester is entitled to attorney's fees. Now, I have at the end of the slide in a question mark, appoint a records custodian. You should have somebody, and it may be you as the director, that's going to be able to respond to an Open Public Records Act request. The Government Records Council feels that the municipal clerk is the gatekeeper, is the records custodian for all matters in all boards municipal, including libraries. But you may get a request directly, and I suspect that the Government Records Council would say, well, you got the request, you knew you had it, you have to fulfill it. So be prepared. Let's talk about insurance. I talked before about the possibility of a discrimination lawsuit or sexual harassment lawsuit. Something like that would be covered by employment practices liability insurance, sometimes known as directors and officers or D&O insurance. You want to check and see if you have that insurance. Now, many of you your municipalities are in a JIF, a joint insurance fund run by the county or by a group of municipalities in a shared services agreement. You want to find out if you have EPLI insurance that'll cover you and your supervisors at your library. You also want to make sure that there's liability insurance and hazard insurance, liability insurance for your employees in case, God forbid, something should happen and somebody should be hurt as a result of the negligence of someone on staff. Hazard insurance to protect not only the building, which I think is a municipality's headache, but also the contents, your books, your materials, your equipment, your furniture. You want to make sure that those contents are covered for replacement value. If not, books depreciate very quickly, as I'm sure anybody that's gone to a friend's book sale knows. And so you want to make sure that you're covered for replacement value. Workers' compensation insurance. Find out what the retention is on that workers' compensation insurance. Retention is akin to a deductible. I had one library who's had workers' comp through the municipality, but they weren't told that there was a $250,000 retention. The library, as a courtesy to the town, had taken on an employee of the town's that the town didn't need or want, but wanted to keep on a payroll. And shortly thereafter, that employee got hurt and ran up medical bills, temporary and permanent disability awards that approached $250,000. And the town asked the library for the money, saying, hey, you're responsible for this. We were able to work it out so that the town picked up the cost on that. But you should know if that's out there and who's going to pick up the retention. And if the town expects you to pick up the retention, you may want to look into having a policy that will cover you for that, if it makes sense from a cost perspective. Finally, unemployment insurance. Find out if you are paying in for the employer part, a contribution for employment insurance. If you are not doing so, and you lay somebody off and that person collects unemployment, the state is going to bill you for all of the benefits paid. Unlike private employers that have to have unemployment insurance, you do not have to have it. But the backside of that is if you don't have it, you're in essence self-insuring and you're going to pick up the tab for whatever. I had one library back in the recession 08-09, laid off an employee because their 1/3 mill funding had gone down. They couldn't afford it anymore. 6 months later, the town who handled their payroll said, hey, you owe us, I figured it was like $20,000 or something like that. And they said, what for? Well, you laid off this employee, and this is the amount of benefit paid. So what about unemployment insurance? Well, we don't pay into it, so you owe it. So you may not get the savings you think you're going to get if you lay somebody off. So let me talk about some policies. Let me begin with a patron behavior policy. You should have one of these. You should spell out in detail what behavior is unacceptable. You want to detail the circumstances under which the patron could be asked to leave the premises, have their library privileges suspended, or have their library privileges revoked. Now, you must provide for due process. That is, the patron has to have the right to appeal, typically to your board of trustees, any suspension of privileges or revocation of privileges. Other policies that you may want to consider having: an unintended child policy, internet use, policy for use of your community room. And you should certainly have, as I mentioned before with the employee handbook, an anti-harassment and sexual harassment policies. And I further recommend that you get training for your staff on these policies on a regular basis, either every year or at worst every other year. I suggest you contact the New Jersey Division on Civil Rights. They offer training on this kind of policy. I don't know how they're doing it now in the age of COVID, but when we get out of it, they'll come to you, as I understand it, and put on a training for you. So if you do an in-service day for your staff, I would suggest that you do this on a periodic basis. Friends of the Library. Friends are a nonprofit corporation formed under the Nonprofit Corporation Act, whose purpose is, or should be at least, to assist the public library. Now, in addition to forming as a nonprofit under state law, a friend should get a 501c3 designation, meaning they're tax exempt and donations to them are tax deductible. Now, friends shouldn't be running the library, but they should be raising funds to augment the library budget or to further library purposes. Now, the friends are not covered by the local public contracts law. So if you've got a really good friends group and they could raise a lot of money, instead of giving money to you to do things, they, for example, could buy furniture and not have to go out for public bid or state contract or whatever. They could go out and get the best deal they can, then they can donate the furniture to the library, as an example. Finally, let me conclude by talking about your role as director. My opinion, you are the chief executive officer of the library. The civil service job description, for those of you that are in civil service, says that the library director manages and directs the operations of a free public library. And I suggest that even if you're not civil service, that's what you're supposed to be doing. Now, the board has hiring authority to hire all of the staff, but just like it has the authority to buy books, some of this authority should be delegated to the director, whether it's the actual hiring or, at the very least, identifying the need for a position, interviewing candidates, and recommending their hire, and have the board be the final decision on that. Trustees should not be talking to staff about library operations. The staff communicates to the director communicates to the trustees, and the other way around. I would suggest that you have a job description and that you have goals, and that there be performance evaluations done, if needed, to enhance the communication between staff, the trustee rather, and director. I have some boards that do annual performance evaluations for the director, and it's been a help in terms of enhancing the level of communication between director and board and a better level of understanding. I have other boards that say they don't need to do it, but they feel that the director, with their report each month and the work they do with their committees, that the director has a good handle on what the board wants, and the board has a good handle on what the director is doing. So with that, I'll open it up to questions. Michelle and Bob, I know we have some in the Q&A, so I'll let you fire away.
Yeah, Hi, Michael. Thank you for all of that. Bob is here too. Bob, do you want to
I have
start
a
or
ton of questions for Michael.
you do?
Do we want to unshare your screen? Actually, let's keep your presentation up in case you want to go back to other slides and stuff.
Sure, I
So,
can do that.
we have a question from Jen Brenner. She asks, can a county library, which is created by a resolution, so that's the less than 150,000 law, ask to be reappointed as a referendum?
I'd have to know why. I don't know that there'd be
Yeah,
any
let me,
difference as I
I'm
understand it.
getting here, I'm bringing Jen up here. All right, Jen, I have allowed you to speak. You have to unmute yourself. There you go.
Hi, Michael. How you doing?
Hi, Jen.
So because the library was created by resolution, it could also be dissolved by resolution, which means like, the commission can just decide that they don't want a library anymore. So I was wondering if there's a way for us to ask to be added to a ballot to be a referendum so that we could then be not dissolved so easily.
Yeah, well, I guess you could. I've never seen it done. Here's the risk you run. You lose the referendum.
Yeah, then I'll be screwed. But
Yeah. But on the other hand, if you think that that's a possibility, then that is that the county commissioners are going to undo you by resolution, then you're going to want to try and get on the ballot. But I would suggest that you wait until they actually try and do it. That is to undo you, if you will, to dissolve you, and then I would go to the voters. I've had 2 instances with municipal libraries where, in both cases, association libraries, in which the municipality either cut the funding or cut the funding to the point where they had to get out of their regional co-op. And that spurred a resolution to make both of those municipal libraries. So you got to weigh out the politics of it. But if I were you, I don't know that I'd be jumping into it now before there's any hint that there's going to be a problem. I'd wait until at least the problem was well known before you try and get on the ballot.
yeah,
Michael,
just something for my to keep in my back pocket in case it became an issue again. It has in the past, but just in case it comes up again.
Michael, this is Michelle. I'm just asking if you could expand on that a little bit. So I've seen where this has come up with municipal libraries discussing this, but boy, that seems like pretty difficult thing to do for a county library, which would have a headquarters and maybe multiple branches in a number of towns. So you've never seen that done, and it just seems really complicated if you have, some of these county libraries. I know some are smaller, but some of them have 12 branches or 20 branches. I mean, how would they?
I think the thing to consider with this is that there really is only one county library right now that falls into this, and that's Cumberland. I mean, in theory, if Salem County wanted to make a county library, they could use the same law, I would imagine, since their population is also under 150,000. But right now, only Cumberland would fall into this.
Yeah, and Jen, you'd have it easy to get a petition on the ballot because it requires only a petition signed by 300 voters, which is a fairly low threshold to get a question on the ballot. Contrast that with the Johnson legislation, which would require 15% of the voters in the last election. So, so you can do it, even if they were to vote to dissolve you by resolution. You could get something on the ballot. But as I said, I haven't seen it.
Okay. Jen also has another question just while she's allowed to speak. I'll ask it. She asked about the excess fund. What are the repercussions if the municipality doesn't follow the return of excess fund procedures and get approval from the state librarian? Now, remember, that's only for municipal libraries. It's not for county libraries.
Right.
So,
well, if the library just turns it over, or worse, if the municipality just says, hey, we're not going to give you all of this money since you have so much extra money, you can report it to the state library. I'll leave it to Bob and Michelle to describe if there's anything they can do. The only other avenue I can think of is you'd have to go to court.
I mean, I would definitely communicate with the Division of Local Government Services, which we coordinate with these applications. They have to approve all municipal budgets. And I would imagine if they had a report from us that a municipality was kind of padding their budget by taking money from a library outside of the normal statutory mechanism, that they would have something to say to the municipality. But
They
thankfully,
definitely would.
thankfully, we haven't had to do that yet. But if we did, that's pretty much what I would think we would do.
Well, I think we have contacted DLGS when that happened before, but normally, or no, I shouldn't say normally, but what we have done is when we've become aware of this, we have called and spoken to the municipal, CFO and explained the situation, because oftentimes they're not aware of the return of funds law. So I can't, they're not happy about it, but then once we give them the statutes and explain the way the whole thing works, oftentimes they go back and make the library go through like the proper channels to do this. And then we let them know whether there, can be a return or not.
Yep. Okay. Thank you, Jen, for that. Heidi Kramer asks, can trustee bylaws be revised to allow for joining by conference call or Zoom beyond COVID?
Yes. And Robert's Rules even has a provision in there for people to join remotely. Now, once we get past COVID, the whole board can't meet remotely, but you can certainly have trustees that call in or join by Zoom or WebEx or one of those. However, in order to be able to join a meeting in those circumstances, the trustee that is remote will need to be able to hear everything that everybody is saying in the meeting and be heard by everybody, and also have all of the materials that everybody else has. Either they physically have it, they've gotten it electronically, or they can see it like we're doing now in a share screen arrangement.
Okay. So with regard to the Open Public Meetings Act, what standard announcement / statement should be made at the start of each meeting?
Okay. So you would say, pursuant to the Open Public Meetings Act, adequate notice of this meeting has been given to paper number 1, paper number 2, has been posted in a prominent location at the library and provided to the municipal clerk at least 48 hours in advance. Then you would also go into how you provided electronic notice, so that it was posted on the website at least 48 hours in advance, that there was a link provided to join, or if you did it on other social media platforms like Facebook or Instagram or Twitter, you would describe those as well. You would also describe during this public emergency the fact that the public can join and can comment, and the method that they could do.
Okay. Thank you. All right, next question. Melissa Kuzma asks, what do you think about a mayor being a library board president?
There's nothing that would prevent it. I don't know why the mayor would want to have that responsibility. However, if the mayor is pro-library, I think that can only be a good thing. If the mayor is not pro-library, then it's not a good thing. But I don't think there's anything you can do to prevent it.
Yep. Parinda Desai asks, my board president and one other board member have the signing authority along with our board treasurer on checks. Only our board treasurer is bonded. Do the president and other board member need to be bonded?
Yeah, either bonded or some kind of fidelity insurance. I would check with the town. The town probably got the bonding for the treasurer. I would make sure, because if you have 2 signature authority, those 2 officers that don't have, aren't bonded but have signing authority, they could write out a check to themselves, and next thing you know, you have no money, and they're in some island somewhere there's no extradition treaty. Now, that's obviously a bit of a stretch, but nothing to say they couldn't embezzle money. And then there's no bond to back it up, and so you're out. So I think that the responsibility to taxpayers is such that they should be bonded or otherwise insured. I think sometimes they call it a fidelity insurance policy to cover those people that have signing authority.
Okay. We have a couple questions about library security camera footage and the Open Public Meetings Act. So what about library camera footage? Who can ask to see that? Can the town council see it? If there's an accident between the DPW and a patron in the parking lot? And are they subject to the same confidentiality as records? And what about interior versus exterior cameras?
So I'm assuming you're talking about the Open Public Records Act.
Yeah,
And that the security cameras are just what it sounds like. You're there for security. And so I don't see that as a library record. Now, yeah, I guess there could be a camera that is pointing at the circulation desk, and you might see what somebody is checking out. So maybe there has to be a redaction of that. But generally speaking, I don't think that security footage is something that would require a court order or a subpoena, for example, to get, whether it's indoor or outdoor. To me, the purpose of the camera and preserving the recording for a period of time is if there is a problem, whether it's an accident or an assault or something else, that you could turn it over to the police. You could call the police and say, hey, we had somebody in here harassing this person or who assaulted this person. If the police come and they see a camera, they're going to want to be able to see the camera footage. They're going to want to see it so that they can have a very accurate description or get a picture so that they can circulate it. And I don't think it behooves anybody, the library staff, patrons, anybody, to say, no, we can't give that to you. You need a court subpoena for that. I think you want to turn that over. Now, again, if there is you could see what the person is checking out. You got to find a way to see if you can redact that or blur the image. Perhaps, although the countervailing argument is if it's something that if Bob's the guy ahead of me in line and I can see that Bob is checking out War and Peace, or an autobiography of Abe Lincoln, well, I know Bob's checking those books out. But you're not getting it from the library record. You're getting it because it was open and notorious to the public. But to be on the safe side, if you can find a way to blur it, it's probably the best way.
Okay. So Karen Brodsky asks, can a library post on the social media page of another entity? For example, can they post program information on a community forum? And then can the library respond to comments about the library on another entity's social media page?
Sure. In other words, you post, I know that, public access cable, libraries post their programming on that. If you post it on somebody else's social media, that's fine. And the only caution I would have is that you've got to make sure that social media account is proper, if you will. It is something that is not going to be putting out other material or other viewpoints that may make the library look bad. But I don't think there's any problem at all with you utilizing that as another public platform to notify the public and engage with the public.
Okay. Do closed session minutes have to be given to the director and kept available in the library? Does a specific trustee have to keep them? If not, how should a director respond if the executive session minutes are requested under the Open Public Meetings Act? And to whom should the director refer the requester?
Well, so you should have a process for all of this. Executive session minutes should be kept securely. Now, if the director was never the subject of an executive session, having the director that had access to those minutes would be fine. However, if the director is the subject of those minutes, then you may want to have something else. And it may just be a file cabinet in the business office of your library, and the access to which is with your board president and board secretary. I know different libraries do different things. Many have the director take the minutes. Some hire somebody to take minutes. Others, the board secretary actually fulfills that function, which is what I think the secretary's function should be with the board. And so that person would keep it. The one thing I would avoid doing is keeping those minutes in the trustee's private home or business office. It should be kept in the library in some fashion because it is a public record and should be kept by the public.
Okay. All right. Linda McFadden asks, could you please go over the guidelines for emailing board members again? Thanks.
Sure. When you email board members as a full board, you want to put them in the blind, all the addresses in the blind CC line if you use Outlook or one of those, or if you have a way of doing undisclosed recipients, doing that. In that way, when anybody goes to reply all, they'll only reply to you, and they will not reply to the full board. If you put the full board in the to line or the CC line, then if they see something in the packet and they want to start having a discussion or ask questions and they reply all, now the full board is seeing the question, sees the answer, sees the give and take. That's what's supposed to happen at the meeting. And so you avoid that by putting that in the blind CC line, because then nobody sees the reply.
Good. Okay. Alan Kleiman asks, our township currently handles our funds. Can you review again what a board can do if they no longer want that agreement or that arrangement and want to manage their own money?
You'd have to present it to the town and point to the statute that says that the statute says you're supposed to pay the money over to us. We want the money paid over to us. Now, there can be complications with that. Who's handling payroll, for example? If the town's handling payroll, they may want to hold a reasonable amount for payroll so that they know they're going to have that money and then settle up at the end of the year. I would suggest you talk to them about some kind of a shared services agreement if they're going to handle some part of it, but not all of it. So, for example, if they handle your payroll, maybe they handle purchasing. If, on the other hand, you as the library are going to handle everything, payroll, purchasing, all of that, then you've got to just, tell them, listen, this is what the statute says. We want it paid over. It's supposed to be paid over quarterly, and you've got to work with them to try and make that happen.
Michelle Albert asks, are there procedures to take when posting for a civil service position? Are you supposed to post to the civil service website or other places?
There, I'm going to direct you to contact civil service, find out who the civil service rep is that is assigned to your region. And that person will walk you through the process. Rather than me tell you my understanding of the process, it's going to be their understanding that's ultimately going to govern. And you should try and establish some rapport with that representative so that you can get responses to your questions directly.
Okay. Two more questions, and then I think we're good for a break. Is there a length of time the library should retain library board meeting minutes?
Yeah, forever. Although I've never looked at it. I don't know if there's anything in the records retention requirements of the state with regard to minutes, but as a general matter, and especially now in an electronic age, I would suggest you keep them all, if for no other reason than historical purposes. I've had libraries go back decades to answer questions, not the least of which was to determine whether or not they were a municipal library. One of the first questions I ask when there's an issue, are you a municipal library? When were you formed? And they don't know the answer to that. And so they don't know if they just came into existence or if there was a referendum. And there's a difference for that. There may be other reasons for keeping those. For example, if you're trustee terms are out of stagger, to try and go back and do a detective search, if you will, to determine how that happened. But again, in an electronic age, I would suggest you keep them.
Okay. And lastly, can libraries require a patron to sign in with a phone number or email during the library visit and give that login sheet to contact tracing or the public health office if someone reports COVID positive?
You can certainly ask for it. In this day and age, that may be a sound thing to do. You may just want to, get their library card and scan that in some way so that you have that. I know that is something, for example, I know that in higher education, the Office of the Secretary of Higher Education required, before colleges could open, even with limited in-person classes, had to have a plan, and part of that plan was how to do some level of contact tracing, how to know who was coming in and out of the buildings. So yes, I think that there is something that you can do. Now, obviously, you're only going to release that for the purpose of contact tracing and not for any other purpose.
Exactly. Okay. Hold on 1 second. Public session. Just one last question really quick. In public session, in a board meeting, are members of the public required to give their name and address?
You can make that a rule that they have to give their name and where they're from. I see that consistently. That's a reasonable requirement so that you know whether it's somebody from your town, for example, or somebody who just happened to stop in and or frequents, is part of the consortium that you're with, but is not a resident. I think that is a reasonable request that is made, but you should put that in the resolution that you do that governs public comment.
Okay.
Okay, thank
Great.
you.
I think we're ready to.
Yes, we are. Thank you, Michael, for a great presentation. There's a lot of information in there to digest. And right now we're running perfectly on time. So we're going to take a 15-minute break until 11:15, mainly to give Michael a chance to recharge, get some coffee or something to drink, because he is our next presenter too on purchasing. So everyone will reconvene here at 11:15 for Michael's presentation on purchasing. Okay, hang in there, everybody. Thank you.
Yeah.
Oh, good. I didn't get that. Okay, welcome back, everyone, and welcome, Michael, back to our director's training. And I just want to say that before we start with the presentation on purchasing, I want to thank Michael for doing this for us, because we've had a number of people over the years doing this presentation, and it's always, very difficult to understand. And I don't, after seeing many presentations on it, I still didn't get it. So it's always good to repeat it. And thank you, Michael, for doing it for the first time today. So we have about an hour for this presentation with Q&A. And again, please put your questions in the Q&A box and not the chat box. So welcome back, and welcome back, Michael. I'm going to turn it over to you for purchasing basics.
Okay, thank you, Michelle. And hopefully I won't further confuse you with this stuff. So once again, starting off with my disclaimer, these materials are, and the information I'm presenting, not to be constituted as legal advice. Our participation in this seminar does not create an attorney-client relationship, and you should contact your attorney to obtain advice with respect to any particular question that you may have. Okay, here's the outline for this presentation. I'm going to discuss at some length the bid threshold and different aspects of that. I'm going to discuss exceptions to the bidding requirement. We'll talk about when you need quotes and when you don't need quotes. We'll talk about hiring professionals, the length of contracts in general. I'll briefly talk about prevailing wage. I'll spend some time discussing pay to play, how you make an emergency purchase, the need for a business registration certificate, how you get to pay your bills, and dispose of any property that you have that you no longer need. So let me start out with the provision of the local public contract law, and I have it up on the screen. It says that every contract for goods or services, the cost of which in the aggregate exceeds the bid threshold, shall be awarded only to the lowest responsible bidder after public advertising for bids, except as provided in statute. So I'm going to break this down into 4 components. First, I'm going to talk about the bid threshold, which I've underlined, bolded, and italicized. Then I'm going to talk about what in the aggregate means and how to deal with that. We'll talk about lowest responsible bidder, and we'll talk about exceptions. So, the bid threshold. The bid threshold is statutory with a provision for adjusting it. It changes every 5 years on July 1 in years ending in 0 or 5. The last change was made July 1 of last year. Now, there are 2 different thresholds, and it depends on whether or not you have a qualified purchasing agent handling your purchasing. If you don't have one, and the majority of libraries that I've dealt with do not have one, then that bid threshold is $17,500. And I should point out, that threshold does not change every 5 years. That is static. However, the bid threshold for the QPA does change, and it changes, as I said, every 5 years, and is currently $44,000. Now, it's not just a question of saying I'm a qualified purchasing agent or I'm appointing somebody to be a qualified purchasing agent. In order to be a QPA, you have to pass an exam, and you can't take the exam until you can show that you have 2 years of college or equivalent experience and have acted for 2 years as a purchasing agent, not a qualified purchasing agent, just that you've worked as a purchasing agent, and you've taken the courses that are listed there that I know are offered through Rutgers. There may be other community colleges or other higher ed institutions that offer those courses. Long story short, it takes a while to become a QPA. Now, you may be able to use the services of your municipal QPA, that is the QPA in Town Hall. Again, another reason to try and generate good relationships with Town Hall. Or you may find someone out there who freelances as a QPA and will do things for you on an ad hoc or project basis. So, in the aggregate, even the aggregate means you can't divide a contract. They have to be things that you're doing that are the same in quantity or the same in character, are things that are supposed to go out to bid if you exceed the threshold. So let's assume for the purpose of this, your bid threshold is $17,500. And in January, you award a contract to ABC Cleaning for the 6 months, January 1 to June 30, for $10,000. Now in July, you decide, hey, we're going to do this again. So this way we didn't have to put it out to bid. We'll give them another contract for $10,000. We didn't exceed the bid threshold because each contract was only $10,000. Not correct. It does exceed the bid threshold because it's all in 1 year and it exceeds $17,500. That contract should have been put out to bid at the end of the year, the prior year, or at the beginning of this year. So what happens if you start out with not thinking you have work or purchases that are going to exceed the threshold, but you find out that you are exceeding the threshold? So a couple of examples. Here's the first one. As of September 30, you have purchased $15,000. I've picked chain link fence. It could be whatever it might be, through quotations. Now in October, you find out, well, you misestimated what you needed for the year. You need another $10,000 of chain link fence this year, and you're going to need another $21,000 worth of chain link fence next year. Now you know you need $31,000 worth of chain link fence it will exceed it, the threshold this year and next, you've got to put out to bid the contract for that $31,000 in fencing that's needed for the remainder of the current year, as well as the $21,000 you need for the following year. Now, continuing in that vein, again, you've purchased the 15,000 for the current year, and now you find out you only need 10,000 more for the current year, and you don't need anything else for next year. Then you can solicit quotes, or you could publicly bid, it's up to you, that remaining amount, because the remaining amount is above the quote threshold and below the bid threshold. Similar scenario, you've already bought 15,000 for this year. You'll only need 10,000 for this year, but only 5,000 next year. So the total you need is 15,000 below the bid threshold. You can again solicit quotes or publicly bid, but you don't have to publicly bid the remaining amount because it is between 15% and 100% of the bid threshold. Now, what does the lowest responsible bidder mean? Unfortunately, you have to award to the low bidder. Even if you think that the low bidder is not good, if they're otherwise qualified, you've got to give it to them, unless you've had an adverse experience with that bidder yourself. Now, the regulations for this break responsible bidder into two parts, a responsive bidder and a responsible bidder. So a responsive bidder is someone that meets all the terms and conditions of the specs, has provided everything that's required of the specs, and that person's responsive. If that person leaves something out of the specs, which in the specs or by statute, you have to disqualify the bid, then that person is not responsive, and therefore you don't have to take that person's bid. Responsible means that they have the ability, the capacity to do it. They have the experience and they have the equipment to be able to do it. In other words, you wouldn't hire a plumber to do your electrical work, even though they had submitted a bid. If they can't show they have a licensed electrician on staff and they have the equipment and whatnot to do it, then that person isn't responsible. Putting things out to bid. You have to, if you have something that's over the bid threshold, and the most common thing is some kind of construction work, but there could be other things. You have to give it enough time to promote that as people would become aware of and would submit competitive bids. But the minimum is 10 days. Now, when you receive bids, you can receive the bids before the date, but you can't open it. All the bids remain sealed, and they're all opened at the same time. That is the time and place that's stated in the ad. So you could have had an advertisement for bids for the renovation of your children's room. And those bids are going to be opened up on Wednesday, February 17 at 2 p.m. In your business office. At that time, people may show up and hand the bid to you, or you may have received it in the mail or by FedEx or UPS or hand delivery in advance. At the appointed hour, at the appointed place, you are now going to open those bids in front of anybody that's there present. You're going to announce the contents of that bid. So you'll announce that ABC General Contracting has submitted a bid for $25,000. They have the bid security. They have their list of subcontractors, etc. Now, at that time, once you've opened up all the bids and you've announced all the bids, the bidders may want to examine the bid packages, and they are allowed to do so in your presence, but they can't take the bid package with them. Now, many times, especially in construction, they want to see who the subcontractors are. Many of the general contractors use the same sub. And if XYZ Contracting underbid ABC, but uses the same subcontractors. Either the subcontractors are giving better prices to XYZ, or XYZ is cutting it short themselves. Now, the date for opening bids cannot fall on a Monday and cannot be on a day that directly follows a state or federal holiday. And I think that is to avoid rushed bids after a long weekend, so that the bids are competitive and more accurate. Now, rejection of bids. The fact that you've received bids doesn't mean you have to accept the bids. If the low bid exceeds the cost estimate or appropriation, the budget in essence, you could reject. You might decide, you know what, we went to all this trouble, but we don't really want to do this project anymore. So if you're going to abandon the project, you can reject the bid. If after you get the bids in, you say, your architect may say, you know what, these things came in around the budget, and I know you got the money, but I see ways you can save money, and I think we can substantially revise it. Or when it was out on the street, you had comments and you've decided to revise your design substantially, that's a reason to reject. Or when you're purchasing goods and services, if you decide to use a state authorized contract. Now, there are exceptions to the bid requirement. All library materials, books, DVDs, subscriptions, rebinding, specialized library services, they are accepted from the public bid requirement, meaning you don't have to do a sealed public bid. Professional services, attorneys, architects, auditors, extraordinary unspecifiable services, an EUS. The most common example that I've been able to find of that is website design. Your public utilities, electric and gas, for example. Expenses for travel and conferences. State contracts, or if you deal with a regional or national co-op, those are accepted from the public bid requirement. However, pay to play may and likely does apply, and I will get to that in a little bit. Now, what happens if you have purchases that are below the bid threshold? If they are below the bid threshold, but above the quote threshold, and the quote threshold is 15% of the bid threshold. I've done the math for you, so you see that with a $17,000, $17,500 limit, it's $26,25, and I have an error on my slide there. I'm sorry, I don't. $26,25 to $17,500. If you don't have a QPA, you need two quotes. Between $6,600 and $44,000 if you have a QPA. Now, in awarding quotes, you're not married to the absolute low bidder. You may award to a vendor whose response is most advantageous to the library, price and other factors considered. So, for example, you have a plumbing problem. Let's say you've got a backed up waste line, and your downstairs or children's room restroom is not available to the public, but you have another restroom, so it's not an emergency. Plumber number one gives you a quote of $5,000, but he can't get to the job for at least 30 days. You've got some children's programming coming up. You'd really like to be able to get the children's restroom online earlier. Plumber number two can do it for $6,000, but he can come in tomorrow and do it. Under that circumstance, I think you're perfectly within your right to pick the plumber number two for $6,000 because he can come in and do it really quick. Anything below the quote threshold, you're on your own. You just have to demonstrate sound business judgment for why you selected that person. Now, many purchasing agents just apply the criteria of the quote threshold. They'll get at least two, no matter how low it is, and they'll use the most advantageous criteria. When it's below the quote threshold, though, you don't have to get two. Note that all contracts for goods or services must be in writing. Now, when you're hiring a professional or contracting for an extraordinary unspecifiable service. If that contract exceeds your bid threshold, your board is required to adopt a resolution stating the reasons for the action and must publish in the official newspaper a notice that states the nature of the contract, the duration, the services to be rendered, and the amount of the contract. Now, if you have a flat sum, like website design, you might have a contract for a certain amount of money, might be $20,000. That would be stated. If it's an hourly rate, like you're hiring an attorney, you would state the hourly rate. You have to indicate that the contract is on file and available for public inspection in the library office. Now, the length of contracts. Contracts cannot be longer than 24 months, except that contracts for professional services cannot exceed 12 months. In addition, there is a statute, part of the local public contracts law, that contains a list of roughly 40 different contracts that can exceed 24 months. Some of those include leasing machinery and equipment of any kind, that can be up to 5 years. Products or services for voice, data, or transmission can be up to 5 years. Construction contracts, including contracts with architects and engineers for construction, are for the time, excuse the typo, necessary for completion of the actual construction. Now, contracts for services, the statutory length of which is 3 years or less, may contain a provision for 1 2-year or 2 1-year extensions if the contract is awarded by board resolution, will run in total for no more than 5 consecutive years. Any price changes based on terms contained in the contract, and changes don't exceed the statutory index rate, and the terms and conditions of the contract during the renewal terms remain substantially the same. Now, any multi-year contract, with the exception of a few exceptions like a construction contract, must conclude a clause that either makes that contract subject to the availability and appropriation annually of sufficient funds, or give you the right to cancel the contract each year. And that's important. Prevailing wage. Any public works project is subject to prevailing wage if the total value of the project exceeds $16,263. Prevailing wage means it's a minimum rate for laborers and other people in construction trades that work on public works contracts as determined and posted by the New Jersey Commissioner of Labor. You see I've defined what exactly a public work is. Okay, if things aren't confusing enough, I'm sure this next is going to do it. And I apologize, but it's what it is. Pay to play, which is the vernacular for this part of statutory law, applies to all contracts that are over $17,500, except contracts with banks, insurance companies, and public utilities. Now, contracts that exceed $17,500 will qualify under pay to play if they are awarded in one of two ways: either through a fair and open process, that is a sealed bid or sealed RFQ, or a non-fair and open process, in which case the contractor has to complete and file with you business entity and political contribution disclosure forms at least 10 days before the board awards the contract. Now, why is that? Well, let me say that in filing the business entity disclosure form, the contractor is saying under oath that in the year preceding the award of the contract and during the term of the contractor has not and will not donate more than $300 to any political party committee or any candidate or office holder for elective office in your jurisdiction. So if you're a municipal library, it would be your town, be any town. If you're a joint library, it would be any town 1 and any town 2. If you're a county library, it would be the county library, anybody holding a county-wide office. Now, why is that? The legislature determined that people were donating money or promising to donate money if they got contracts. And so they wanted to get a way to avoid having people pay money in order to get contracts, pay to play. And so if you do by sealed bid, then it won't matter how much money you've contributed because you're required to award the contract to the low responsible bidder. And so the legislature felt that that was protection enough. People can't pay to play. But if you don't do a sealed bid and you want to award to somebody, then you've got to make sure they have not contributed more than, and the $300 number is a reportable contribution number. So you know. So that's the reasoning behind pay to play and what you have to do to qualify or follow those procedures. Now, you might have an emergency come up. I talked about the plumber before. Let's say you've got a plumbing leak and you've got a flood coming out of that children's bathroom. You now need to get somebody in right away. Neither the bid statute nor the pay-to-play statute will apply if it's an actual or imminent emergency that requires that you do something and the need could not have been reasonably foreseen. So if the roof is leaking, but you knew the roof needed work, that might not qualify as an emergency. But if the plumbing happened to just break, somebody ran into the sink or did something to the sink and now you got water flowing all over the place, obviously a different story. The contract's length is only for the purpose of meeting the immediate need of the emergency. Emergency purchases cannot be used to enter into a multi-year contract. And your board is required to adopt rules that establish a process to determine that an emergency does exist and the procedure that will be used in response to that. Now, all contracting, you're required to have on file for the vendor a business registration certificate if the purchases exceed $2,625. Now, for someone like myself, an attorney, that's going to be whatever service I do throughout the year. For a vendor, it's by type of good or type of work. So if you hire a plumber to do work on your HVAC system one month, and the next month he does work on the bathroom, that's really two different kinds of things. Library materials are not exempt from this, but it does not apply to nonprofit corporations you may have services with or government agencies. Emergency purchases can be contracted without the business registration certificate, but you cannot make payment until you receive the vendor's business registration certificate. You're only required to obtain the certificate one time unless the vendor's business address changes. Now, paying your bills. You should contact your auditor about the process that you need for approving bills. Some auditors use a claims or encumbrance list, others a bills list, others a simple list of checks. But typically that has to be approved by your governing body. And then before you can issue payment to the vendor has to submit a purchase order. You have to provide them with a purchase order or voucher in which the vendor or contractor certifies that the bill is correct and that the money is due and owing. Now, in paying your bills, you are not allowed to use credit cards. Credit cards and debit cards are not allowed. You can accept credit cards so that if somebody has lost a book or wants to make a donation, you can accept the credit card. In lieu of using a credit card or a debit card, the Division of Local Government Services does authorize a procurement card, commonly referred to as a P card. You also may use electronic funds transfers, such as a wire transfer or the clearinghouse process. P cards and electronic fund transfers requires that the board adopt a resolution that includes all of the policies and procedures for implementation and oversight. And I will tell you, P cards require training, require a relationship with the bank, and there is a process for doing it. In a P card, you find out what it is you need to buy and where you're going to buy it. You load onto the P card only that amount that's needed to complete the purchase. And there is a process for allowing that P card to be used. Now, the P card looks just like a credit card, but it's not. You should, if you want to follow up on this, I suggest you consult the local finance notice that I've given there, which is available on the Division of Local Government Services website. Disposing of property. From time to time, you're going to have property that is obsolete. Computers, furniture, things like that. The board's required to adopt a resolution to dispose of the property. If the estimated fair value of the property to be sold is less than or equal to 15% of the bid threshold, you don't have to put it out for public bid. You can do a private sale. You could recycle this stuff. You could throw it in the garbage if it doesn't have any value. However, if the estimated fair value of the property is in excess of 15% of your bid threshold, then you're required to sell at a public sale to the highest bidder, either through a sealed bid or what is common, a public auction. And the public auction can be done on a website, electronically. Now, if you are doing a public sale, the date, time, and place has to be advertised at least 7, no more than 14 days before the sale. However, there is no need to advertise bids when the sale is made to the federal government, the state, another contracting unit, or any governmental unit in the United States. Another contracting unit here refers to another library or another municipality or the county. And with that, I will open it up to questions.
Okay. Let's see. We only have a few. What happens when cumulative work exceeds the bid threshold and that work is for a design service like a new website or interior design that is ongoing?
If it's a website, that's going to be an extraordinary unspecifiable service. And there is a process to follow for that, but you don't have to, you can exceed the bid threshold because the bid threshold doesn't apply. That would be an exception to the bid threshold. If it's something that is subject to the bid threshold, I gave you examples in the slides as to how you would deal with that. So let me just go back here. So, and again, I use chain link fence, it could be widgets or whatever. If you're going to exceed the threshold cumulatively in the given year, plus you know you're going to do it in the following year, then you're going to have to put it out to bid. If you're not, then you don't have to put it out to bid. Now, with something that is like a service, if it falls under the bid threshold, I don't know what you do. That's why I suspect if it's a service, you're not going to be subject to the bid threshold. You are, however, if you're going to go over 17.5, you are going to have to adopt the resolution and you're going to have to publish a notice as to the nature of the contract and its availability for inspection.
Okay. Next question is, many libraries have a line of credit with Amazon. It isn't actually a credit card. Is that okay?
My understanding is it's not. The reason being, you have no authority to enter into debt, and a line of credit is debt. The credit card is debt. The reason why they allow for EFT or a procurement card is because there you're fixing the amount of money that you're spending, and the case of a P card, you're actually loading the P card up. You're working with your bank to say, okay, fine, my maintenance worker has to go to Home Depot and buy $500 worth of janitorial supplies. you're going to put $500 on that card. You're going to then give that card to to your maintenance worker, who's going to go down and buy those janitorial supplies, and only those janitorial. He can't buy ceiling tiles or lumber or light fixtures or anything like that. There's a classification that he can use it for, and that's the purpose.
Okay. As an association library, can we pay some bills using a credit card? Can we purchase with a credit card?
My bad, none of this applies to association libraries, although a good practice would be to follow some of these, like, for example, bidding out higher projects. But clearly, you can have a credit card. Association libraries, and I should have said this off the top, they're the exception to this rule. There is no court case, there's no statute that absolutely requires that you follow local public contract law. There is some suggestion that that's a good practice to follow, but you're not required to follow any of this.
Okay. Let's see, there's a couple more questions coming in as we're asking
Sure.
these or answering
No
these. What do you have to do to disqualify a bidder who you have dealt with before and was bad, i.e. a cleaning service who didn't do good work, but you know will be the lowest bidder?
Yeah, you've got to document that, and then you've got to give them the opportunity to be heard. But if you can demonstrate a prior bad experience, then that is, and if you're telling me that you had a cleaning service that didn't do the job and you documented that during the time they were doing the work, that would be a prior bad experience that would allow you to disqualify that bidder.
Okay. All right. Can you split a contract between two vendors if it goes over 17,500? Could you award January to June with one vendor and July to December with another?
No. No. Take my example of the cleaning services. If you did ABC cleaning for the first 6 months for 10,000 and then did XYZ cleaning for the second 12 months, local government services is going to see you put that out to bid for one contract and let ABC and XYZ compete for the work, and they think would drive down the price.
Okay. Let's see. Does my board need to pass a resolution or sign the non-fair and open disclosure for an extraordinary unspecified service that may exceed the bid threshold?
Your board doesn't sign the business entity and political contribution disclosure forms. The vendor, the contractor does. And you have to provide those forms to them. And by the way, that includes your book vendors. You should be, every year, you should be having them sign those forms, even though books are not subject to the bid threshold, it is subject to pay to play. So if you think there is the possibility that they will exceed the bid threshold, then you have to get those forms signed and filed so that you can award it. And if they can't do that, that is, say, oh no, we gave $500 to the mayor for his reelection, then you can't award to that person on a non-fair and open process.
And last question in the queue, would a purchase order be used for utilities such as the water bill?
No, I don't think so. Check with your order, but my understanding is that doesn't, that's, you get your normal bill and you pay the normal bill. That's what I've seen. But again, check with your auditor to make sure that as to the process on all of that, because I have found auditors, different auditors have different ways of doing things. And I've had auditors that catch things one way, but don't catch them the other. So it's really, sometimes it's peculiar to the auditor. So make sure you consult with your auditor on that.
All right. One last question came in. This person uses their personal credit card to purchase things for the library and then gets reimbursed. And they say that they know many libraries that do this. Is this okay?
Yeah. Again, I would check with the auditor, but if you do it, if you can document it, I would think you're okay. So that I have had people, for example, the statute does provide that rather than to front money for people to go to travel for conferences, for example,
Mhm.
and then to submit a request, to remit the balance back. I prefer, and a couple of auditors that I've talked to, prefer to have the individual employee incur the expense and then submit for reimbursement. So I think that is a permissible thing. One of the things you may find, though, is that people can't afford to put things on their credit card. But to the extent that they can, I think that that would be permissible. But again, you need the documentation. So if your maintenance worker goes down to Home Depot and buys $250 worth of materials and comes back and wants to be reimbursed, well, you need to get that receipt and show and make sure that you're reimbursing the right person. So I'd want to see the receipt and their credit card statement in order to make sure that the reimbursement is proper. But yeah, I think that can work.
Also, what if you do that, but you don't get reimbursed until the next month, and suddenly you're charged interest on this charge for the library?
If it's small enough and it doesn't have to go to your board, again, you got to work with your auditor, but there should be a way to pay that and then have it appear on a claims list or a list of checks. And hopefully the timing of it is such that you're going to get that receipt. And now with the website, you should be able to print something off that shows that, yeah, you've incurred that expense. You don't wait for the bill to come in to be able to submit it for reimbursement. Or you can submit it for reimbursement, put it on the claims list, but before you issue the check reimbursing, you get the other documentation you need so that you avoid that that late charge for the individual or the interest.
Michelle, do we have time for 2 more questions that came in?
Yes, we do. We actually are kind of early, so this is supposed to go to 12:15. We can end it earlier if and have another shorter break if Pat and the 2 Pats are ready to go. But I'd rather.
It's not in yet.
Okay, so and I have a couple questions too. I see a couple more.
Yeah.
So
let me go through those and then we'll
Okay.
see where we're at. What do you do if your auditor is a few years behind? Can you appoint another auditor? Can they do the audits that are overdue?
Sure.
This is not really a purchasing question, but.
No, that's fine. I mean, it goes back to the first, I'll take questions on either topic. I would, listen, I have libraries that change who their auditor is every several years. They feel that's a good practice. Yeah, if you've got somebody who's doing your 2017 or 2018 audit, and you want somebody to do 2019 and 2020, you could contract with a different auditor. Sure, I don't see a problem with that.
Let's see. How do we determine the estimated fair value of property we wish to dispose of? Is there a specific entity we should consult? Do we need to document that process?
In this day and age, you go online and see if you see what other things are going for. So like if you have a 10-year-old computer, go online, go on eBay, go on Craigslist, something like that, and see if you see a similar model being sold, and use that as an estimate of fair value. Furniture, same thing. The likelihood of any of that kind of stuff having any real value is probably slim. But if you had a computer that's only 1 or 2 years old and your board decided, hey, we're doing all new computers and we're going to include you too, and they bond and give you all new computers and you got 2-year-old computers, then yeah, it probably is worth something and you may have to go out for public bid. And when in doubt, you probably should try and go out to public bid. Do something to document your judgment is basically what it comes down to.
Okay. And last question, do you need a receipt and a credit card statement to be reimbursed if you're doing what we said before about purchasing with a credit card?
Yeah, I would, only because, if somebody hands in a receipt, it turns out that they picked it up off the floor at Home Depot and they didn't buy the stuff, that would be a problem. I'd want to know that that receipt matches up to that person's credit card, and you can make sure that you got those materials. So,
All right.
um,
I
That,
have a couple of questions though.
no, go ahead.
go for it,
So
Michelle.
I often hear about the Amazon question. How can we buy from Amazon? So what you were saying is this person had an open line of credit or something on Amazon. How
Yeah.
can you buy from Amazon?
I-
Because they are so cheap, you know?
Sure. Yeah. I think that you got to look into a P card. And I think that a P card can work. I don't know that directly. Unfortunately, I don't work in purchasing.
Mm.
So, you know, I know what the law is, whether or not Amazon will accept it. But again, my understanding is it works like a credit card. From the vendor's point of view, they see a piece of plastic that has Visa or MasterCard on it. Or if you're doing it electronically, you know, you're just putting in the numbers and the expiration date and whatnot. And so I think that's when you really want to look into a P card.
Is it just like my debit card that's hooked up to my checking account on
No,
Amazon?
it's a little different because your debit card, you can run up whatever number you want on your debit card. The P card, you have to load the card. All right. Now the card can be used multiple times, but each time you want to use it, you have to put a dollar amount in there. So you may estimate you need $500 worth of janitorial supplies, and your maintenance worker goes in there and buys $350 worth of janitorial supplies. Okay, you won't be able to buy $550 worth of janitorial supplies with the P card. Same thing with the Amazon. As I understand it, you come up with a P card, you put that information in. But that's something to work with your bank on and with your auditor on.
And
for the
I see
details.
that Alan Kleiman answered that Amazon will accept purchase order numbers, then that he's done that with them in the
okay.
past. So I guess it's a matter of
There
working
you go.
closely with Amazon. And I have another question. And you might have covered this and I might have jumped up for a minute, so I'm not sure, but you know, a lot of times we at the state library have to get 3 bids, you know, for something. So what happens if you put out a call, you know, for bids and you don't get your number that you need at 3 bids, and if they get that, what happens? Like if I we did not get through that one out, and now as long as we document that we out, you know, we're not and get number so is there a number?
2 quotes between your quote threshold and your bid threshold. Now, if you put something out to bid and you don't get a bidder, okay, you ask for sealed bids, you get no bidder, and you do it a second time and you get no bidder, then you can go out and negotiate. That's a rare instance, though. So if you were going to renovate the children's room and you couldn't get anybody to respond to either of the 2 times you advertised for bids, then you could go out on your own. But if you get 1 bid, as long as it's a sealed bid, that is, the public was notified and only 1 person, 1 firm comes in with a bid, that's the bid. Now you may reject it because it comes in too high, but that's the bid. And if it's in the ballpark and you want to go ahead with the project, or the contractor.
Thank you. I think we have some more questions that came in, Bob.
Hi, sorry. Everybody in my house was streaming or doing Zoom all at the same time, and my connection started to get really dead, so I had to go drop the hammer and get them to stop doing that. So we did the question about from Alan Kleiman about purchase order numbers, right?
Yes.
Yes,
Is that okay?
that's when
thank
it's
you, Alan.
anonymous.
Yep. And then you did the one from Anonymous?
No,
No? Okay. How is the credit card purchase different from reimbursing for cash?
In terms of your employee either uses a credit card or pays cash, well, if pays cash, then you're gonna get the receipt, and you're gonna get them to sign that that is in fact, they incurred that expense and to be reimbursed. Again, check with your auditor as to the exact paperwork process they want filed, because the last thing you want with an audit is a note on your audit that you're not doing something right and you have to correct something. That won't look good. I'm not saying it's devastating unless you get many of them, but you want to avoid that where possible. And the best way to avoid that, talk to your auditor about the process to be followed.
Yep. Okay. Let's see. That's just a comment. So the debit card also needs to be loaded to a preset amount every month. How is the P card different?
My debit card does not, but either way, I will tell you that Division of Local Government Services says you cannot use a credit card and you cannot use a debit card. You can only use a procurement, or sometimes it's referred to as a purchasing card, and the shorthand is a P card.
Got it. And last question, probably before the break. What about consultants or performers for public programming? Do these need bids or quotes?
No, they don't. For example, a performer, I don't know that there is a generic performer, okay? You're selecting a performer because they do a style of program that you want, they do it in a certain way that you want. That is not something like going out and buying, the example I use in the slides, chain link fence. Chain link fence is chain link fence. That is a commodity you go out and buy. There might be different, certain variations, but you can specify a chain link fence and you can put it out to bid. You can't really do that for a performer. That probably falls under an extraordinary unspecifiable service. Although, again, I don't know that you're going to find, I don't know what you're doing with a performer that's over $17,500. If you're under $17,500, then you've got a lot more leeway, even if it were something that was not accepted from the bid threshold. So,
Right.
and then did you answer, Mary Ellen? Will the program be posted so I can share with my purchasing staff? And yes, you will get a link to the
Yes.
program. Correct,
Yes.
Bob?
Yep, I'm going to be
Great.
posting it to YouTube as an unlisted link, and we'll send that out to NJ PubLibs when it's posted.
All right, sounds great. So that's all the questions then, I believe?
That's all the questions I have. So,
Okay.
you want to take an early
Michael. Well, yeah, I want to first thank Michael for doing a yeoman's work today. He did a double session and did excellent job. And
Thank
Michael, thank you just so
My
much.
pleasure. I'm going to stick around for Pat and Pat.
Okay.
And if any questions come up in that presentation that they want to direct to me, I'll be happy to help them there.
It
Sounds
sounds
good.
great. Everybody, there's been already some comments in the chat about how great your programs are and, how much I appreciate that we do this from time to time. So, as I said, today we was supposed to be new directors. Thanks to Zoom, we're able to open up to all directors. And I think everybody appreciates the information that you give. It's just so dense that it's, something that you either forget that you learned, or so a refresher is, or you never learned it correctly the first time. So a refresher is always very helpful. And thanks for your PowerPoint on purchasing. Really appreciate all the time that you spent.
My pleasure.
So I hear that you're going to be staying online for us.
Yep.
And the thank yous are coming in from the speakers, from the attendees for you. So you'll stay online. And right now I see Pat Pavlak and Pat Tumulty are here. The two Pats are here. So
The
we're
media.
going to take, so let me just ask the two Pats, if we took a 10-minute break instead of 15, would you be willing to start a little earlier?
Absolutely. Yep.
I don't think anybody would be, would mind if we just started a little earlier and finished
I
a
don't
little
even mind
earlier,
if
right?
I don't even mind if people eat their sandwich while we're speaking.
All right, so let's just, let me do the time. It's 12:08. Let's just say 12:20. We'll come back and we'll get started at 12:20. That's a good 10 minutes earlier. Okay.
Sounds
So so everybody, will see you at 12:20 and for a program on working with your trustees and your board. Get started with our last presentation for today, working with library trustees. And it's almost as if these next presenters don't need any introduction, but I will introduce them anyway. We have Pat Pavlak, who is the president of the New Jersey Library Trustee Association. And Pat's just been a great partner with us to do a number of these presentations and working on the Trustee Institute, and also NJLTA helps to sponsor the United for Libraries licensing webinars that we have. So that's a joint project between the State Library and NJLTA. So we're always happy to have Pat Pavlak join us. And of course, Pat Tumulty, who is the former executive director of the New Jersey Library Association and who is retired. And so, and has nothing to do apparently, so what she told us, but that is not true. Pat is now also consulting and working for the New Jersey Library Trustee Association. So she will continue to help in that capacity, working with Pat Pavlak. So we have the team of the two Pats.
Here we go.
We hope we can keep forever, and I'm going to turn the microphone over to them now, Pat and have them start on the last presentation for the day. And after they finish up, I'll just come in for a minute, just for a little follow-up, okay? So Pat, over.
Okay. Hi, everybody. Thanks so much for joining us today and giving us the opportunity to speak with you as library directors. Obviously, you know, you are the captains of the ship, but you do have a crew behind you, which is your library board. So we're going to talk a little bit today about how you can work with the library board and what exactly the library board responsibilities are. And Pat is going to chime in whenever she feels like she needs to chime in. So Pat, you're there. So I know some of these beginning things Michael already covered with you this morning, so we're not going to go over those again, but these slides will be available if you need them. The basic board basics. And this is what the board is responsible for. Many times we make the assumption that library trustees know what their responsibilities are. And that is a dangerous assumption to make. So we always like to put it out there right from the beginning, what the board is responsible for. Their job is to secure adequate funding for the library, to develop, evaluate, and monitor the budget, to establish the policies that support the mission of the library, to develop and review the short-term and long-term strategic plans, to establish bylaws that govern how the board operates, and to hire, supervise, and evaluate the library director. Most of you are probably working on your budget right now. Budgeting is a very, very important part of the responsibility of the library board. And again, I do want to stress you are the director, you are the captain of the ship, so to speak. But you do need to work with your board, developing your budget. So you know what's involved in doing even probably bring a big influx of people. Are there going to be a lot of new children, English speakers, all of these particular groups who might require programs that need funding? So you want to look at that. You want to kind of keep your finger on the pulse. And this is where the board can help you because they are part of the community. They kind of have an idea of what's going on and they can help you with that. Okay, so once you have your budget together, usually your finance person or your treasurer will review the budget with the director, revise anything that they feel needs to be revised, and then they bring the board the budget for approval. Once the budget is approved, it's presented to the governing body. Just so they kind of know what you're doing. They do have to fund at the state mandated level. If you're fortunate, you may be funded above that level, but if not, you're getting the funding that you're required to get. They have to give you that funding. So you are just kind of showing them what you're going to do with that funding, and you can make the case that that funding may not be enough, but this is what they have to give you. Okay, and once the appropriation is set and the budget is approved, then the board implements the budget, the director implements the budget, and keeps the board apprised of what's going on. Pat, you want to add anything to that?
I do. The theme of the presentation is communication, and I think that making sure that the municipality, now different municipalities have different processes about how, you present the budget to them, but you should make sure that they know what you're doing. Just because you get the minimum third of a mil, don't just kind of slough it off and say they got to give it to me. There's a problem. Well, you want to make sure that developing the budget is part of sort of your communication strategy. And make sure that you take a trustee with you if there is a board presentation, because that person should be the community person who's out there. One of the things I just wanted to kind of comment on from Michael Sarone's presentation, he said libraries are not to pay debt service. And now that we have a lot of libraries getting money from the Construction Bond Act, make sure they don't come back and say like, yeah, we had to bond and now we went out of your third of a mil to pay this debt service. No. They should have understood that debt service bonding comes from them. So as we move forward with the construction program, let's make sure that municipalities are very clear that debt service is not part of your operating budget. Okay.
Right. Yep. Thank you, Pat. And Pat brings up a very good point about communication. It's never a good idea, as Pat said, to only go to your municipality when you have to go to them. It should be part of your operation that you keep your municipality informed of what's going on in the library, that you communicate with them at all times. Don't just go to them with your hand out when you need something from them. Nobody likes that, whether it's a person or a municipality. Once you have the budget operational, you want to work with the library board to make sure that the budget is meeting the needs of the library. So part of your monthly board meeting and your report to the board should be an expenditure report where you lay out the bills that have come in, the money that has been paid out, the revenue that's come into the library that month, just so the board knows what you're operating with. Okay, the board needs to approve your payment of bills. So they can't approve payment if they don't see what the bills are. So you need to make sure that that information is given to your trustees. You want to make sure that you have a little bit of money for unexpected emergencies. You want to look at your operating budget to see if it's sufficient. If it isn't, that's part of your planning process that for the following year that you're going to need some more money. This year, libraries are being asked to do a lot more than they have done in the past, whether it's the grab and go, PPE that they have to buy, Zoom licenses, paying for programs online, all of those kind of things that we didn't anticipate last year. We know that they're going to be in place for at least this year, and who knows, maybe into the future. So you want to look at your operating budget and make sure that you can support those different costs from what you had last year. And just like we said, you want to look at emerging issues in your community. Last year, libraries scrambled, many libraries, to get more ebooks so that they could, when their library was not physically open, they could still provide their patrons with the materials that they wanted. So you want to look at that. Maybe that's something that that's going to be something that you need to look at going down the road. So you just want to make sure that your budget is sufficient for what you need to do. You don't want to be caught off guard if you can help it.
Okay. Okay.
Pat? Yep. Pat, just interrupt me anytime. I can't see you, so.
All right. Okay.
Okay, another important role of the board is to develop the policies that govern the library. Lots of boards run into trouble when it comes into policies because they confuse policies with procedures. So the board develops the policy. The policy supports the goals, the objectives, and the mission of the library. Okay, and that policy is developed together by the library director and the board. But the director is responsible for establishing the procedures that implement the policy. Okay, so the library board should not be involved in the day-to-day running of the library. That is the director's job. And sometimes trustees don't understand that. So once they have set a policy in place, it is up to the director to bring the procedures forward that are going to reflect that policy. And make sure your trustees understand that because there's a big difference.
I just want to say, during the pandemic, I think we've all been, we've had to change policies rather rapidly in terms of being able to produce the same services. I think we're helpful having some of those programs in the beginning with the State Library and NJLTA, how you would do online meetings now. You know, there's been, the pandemic has brought together a real need to really look at your policies and make sure that they are sufficient to operate in this environment, which is different than our prior environment. So you're going to have to make sure that you keep kind of constantly looking at those policies. And I know the State Library and NJLA try to keep track of things that are changing on the state level about requirements, but your policies need to be updated, and they may need to be updated quickly to reflect different changes that are going on, particularly during the pandemic.
Right, exactly. So that's why we say that you need to review policies and you need to revise them if necessary. And that's where the role of the director is very important, because sometimes library trustees are not cognizant of every policy that the library has. So you might find yourself in the position of pointing out to the trustees that you need a policy for this, or the policy we have for this is not working and we need to revise it. So don't make the assumption that trustees always know. We hope that library trustees come to some of the workshops that our group makes available to them, and they know what their responsibilities are, but that's not always the case. So as the director, you may need to point out the policies that you need the board to put into place, or you need them to fix.
Yes, absolutely.
The other important role that library boards play and trustees is developing a strategic plan for the library, both a short-term and a long-term plan. And that should be done together. Usually we advise libraries to have a strategic plan that spans 3 years. I know some libraries go to 5 years, but I feel the way things are changing nowadays, that 3 years is kind of the time period that you should be looking at. So just some of the things that you should address in your strategic planning. Where is the library now? Where do you want it to be? How are you going to get there? How is that going to impact your staff and the budget? What is your library's role in the community, and what's happening in your community that might impact the library? And this is where, again, trustees can be very important and very instrumental in helping the director develop this plan, because they are out in the community. They are involved in different groups. They know what's happening in the community. It's very important to get community input into your strategic plan. What's your library doing right? What can you do better? Is there something that you're not providing that your patrons are looking for? What about the people who never come into the library? Why is that? So you want to have that big community outreach when you do your strategic plan, and trustees can be very instrumental in making that happen. And you want to work together. Again, you are the director, you are the head of the library. So you have a big role to play with this, but you have to work closely with your trustees and your community to do this.
And I think, again, back to the previous presentations, you really need to make sure that your capital needs are always updated. The capital needs of the library. I know that's not the most sexy thing to do, to find out that the roof might be leaking, but that is one of the things that really needs to be articulated, planned for, the needs. Many buildings in New Jersey are old. Even buildings that were built in the 60s are not adequate now to provide the kind of services that we're doing in 2021. So you got a part of your strategic plan definitely has to be a real evaluation of your physical space as well as your community needs, because that space is going to direct how your community goes into the future. So capital needs is a very, very important part of your strategic plan.
Yeah, absolutely. And especially now with the pandemic and the way our physical spaces in the library have changed, you might find yourself in the position that you need to address some of these inside concerns in your library. And that money cannot come out of your general operating funds because you probably just don't have it in there. So that's the kind of capital planning that you need to look at. Okay, I know many libraries this year were looking at their HVAC systems and looking at their air filters and all of those kinds of things. So those are big ticket items that you really do need to pay attention to. And that is something that you can take into consideration when you do your strategic plan. Probably the most important thing that the library board does is to hire the library director. You are the only employee that the library board is directly responsible for. You report directly to the board. The board is responsible for recruiting and appointing the library director. They are also responsible for evaluating the library director. They should be monitoring you, and by monitoring you, I don't mean looking over your shoulder and commenting on every single thing that you do, but there needs to be accountability. You should have at the very least a performance review on an annual basis, and that should be a written review. And if the board is unhappy with anything that you're doing, that should be put into writing. And you should be given the opportunity to correct this. Lots of times we have issues where a board may not be happy with the library director, but because they're not communicating with each other, the library director doesn't understand the expectations of the board, doesn't understand why the board is unhappy. And then all of a sudden you get to that situation where the trustees are no longer happy with the director and maybe want to end the relationship. But to be fair to the director, you really have to communicate. You have to communicate expectations, and you have to review the performance. And if you're not happy, you have to tell the person why you're not happy and give them the opportunity to correct what you feel they're not doing correctly.
So on the opposite side, as the director, if your board said, oh, we don't need to evaluate you, that's fine, we just love you, I think you should have your own yearly report to the board about your accomplishments, about what you've done, and make that a scheduled part of one of your meetings. Don't let them get away with saying, because boards will change. And so Mary may have been your board president last year, she loved you, everything was great. Well, now Fred's your board president, and Fred has very different expectations. He looks in the file, there are no evaluations. You haven't made a report to the board about your accomplishments. I mean, so that's a proactive thing that you need to do. And again, as Pat has said, during this pandemic, I think just highlighting how wonderful you've been able to turn on a dime. You should have to document what has happened, particularly during this year, and the leadership that you have shown as library directors to get through this. And I think it's a very important part. So don't let a board say, oh, we don't need to evaluate you. We just love you. If they don't want to do an official evaluation, you do a proactive report to the board highlighting what you have accomplished.
And I'm going to disagree with Pat just a little bit, because I'm going to say if your board is not giving you an annual evaluation, you should insist on it.
Well, yeah, right.
Yeah, because that's just the way it should be done. All of those other things that Pat said, absolutely true, but I would insist on it if I was the library director, because as Pat said, you know, your library board is going to change. And just because this board thinks you're doing a great job, next year's board might not.
Right. Absolutely agree.
Yep, we agree, Pat.
Agree. Agree.
So some of those things that Pat was saying that you know, you're going to tell the board about the job that you're doing at the monthly board meeting, that's going to be your opportunity to do that. All right. So for every board meeting that you hold, you should prepare a packet of information. You know, we used to get a big manila envelope in the mail about a week or so before the meeting. Now, most of us, I think, are getting things electronically, but you should send that packet out before your board meeting. You should give your board enough time to look at it. So you don't want to send it out, you know, 2 hours before the meeting. And the package should include, at the very least, an agenda for the meeting, the minutes from the prior meeting, a director's report, any financial reports that go along with that, and any other material that you feel the trustees have to look at before the meeting. Okay, so anything that you're going to discuss, anything that is going to require a vote or some kind of decision by the board, you want to give the board the opportunity to look at that before the meeting, so they can be prepared with questions, they can be prepared to make a decision, they can be prepared to vote if it's something that requires a vote. Again, this isn't your opportunity to communicate that word that we talk about all the time. All right, so at your meeting, usually the director sets the agenda for the meeting. Sometimes the board president does, but between the two of you, I know at my library, my director sends the agenda after consulting with me about what should be on the agenda. But at the very minimum, you should have your open public meeting statement, the approval of minutes, the board president's report, your director's report, a financial report and approval of the bills, committee reports, old business, any new business that comes to the board, and a section for public comment in the meeting.
And that's a very important, and again, that's very important. Michael went over some of that in the age of Zoom, how you make sure that the public has the ability to comment on your agenda items. And I think one of the things that's also is sometimes difficult, because the board is going to be looking at a policy. The public can't see the policy yet. And so sometimes it's very, that's the hard thing. And I think we have to, I've seen different boards who have put the public comment section. Some of them put it higher than before new business. Some of them put it at the end, as Pat has suggested. So I'm not really sure where the best part of that is, but you have to make sure that the public is aware that they can comment, and that they can see the agenda, at least have an idea what's going to be on it, because that's a very key component of that. And again, make sure that your board gets anything that they're going to vote on well ahead of time, because you don't want to use valuable time with some poor board member going, well, I didn't see that, and I don't know, and you want to make sure they're very clear about what you're voting on. Maybe it'll take 2 meetings, but you should make sure that they have it well in advance so that they can look at it.
Absolutely.
But remember, tell them they can't be having little sub meetings by themselves, They can't do that. We've talked about that before, the board, they can't decide to have a little caucus among themselves. That would be violating the Open Public Meetings Act.
Right, exactly. So we come back to that word, which is a big favorite of mine, and I'm sure it's a favorite of yours, and that's communication. You want to keep the board informed about what's happening in the library. When you give your director's report monthly, This is a great opportunity for you as a director to fill the board in on everything that's happening behind the scenes. You know, I used to say trustees would know what's happening in the library because they'd be in there checking out books and everything. Obviously, that's not true right now. So a lot of what's going on in the library, especially now, they're only going to know because you are letting them know. So you want to make sure that you communicate, use this opportunity in the board meeting to really communicate with your board. Break down the statistics. Don't just give them a report of circulation. This is up, that's down. People are using this, they're not using this. What do you see in that trend? Why do you think this is happening? Talk about what those statistics mean. Talk about what you're doing. Talk about what your staff is doing. Let the board know that this is what's happening in the library, especially this year when things were so different and people had to really change, and they had to change quickly to serve their patrons. It's important that the board knows that this is what you're doing, that you're recognizing that this is a need that needs to be addressed, and you're doing that. Talk about budget concerns that you may have as the year's going on. If you're seeing that this is costing a lot more than you thought it was going to cost, how is that going to affect the budget for next year? Just communicate with the board. It will go a long way to preventing problems down the road. Okay, you also want to make sure every board will have different subcommittees and chair people of those subcommittees. So make sure that you're communicating. Make sure you know who the chair people of your building and grounds, your personnel committee. Make sure you know who those chair people are, and make sure you communicate with them if there's an issue that comes up in their area. You should also keep your board president informed. Now, that doesn't mean that every decision has to be approved by your board president. That's not true at all. But you want the board president to know what's going on, so that if the mayor calls the board president and says, you know, what's happening here? Why is the library still closed? You want the board president to be able to give a cohesive answer that is going to be in line with what the mayor would hear if he asked the director the same question. You don't want people, you know, giving out information that may not be correct. So it's really important that you communicate. As the director, it's your responsibility to welcome new trustees to the board and give them kind of the basic information about the library. Give them a copy of the board directory, the bylaws, the latest annual report, the library policies, the meeting schedule. Welcome them aboard to the Board of Trustees, and give them the information they need so that when they come to their first meeting, they're not blindsided. They have a little idea of what's happening. Again, don't assume that they know what's happening.
And you have a really unique role of turning your trustees into community advocates. That is really one of the things that you can do better than anybody else, is by the information, like Pat has said, that you give them. You know, in my career, I've heard of sometimes when trustees have come on and people have been a little leery that perhaps they were not the most supportive of the library. Once they work with a really good director who's telling them what's going on, they turn them around to become an advocate. So that is really your opportunity to take the community, to take somebody who might have been a doubter. You know, you get people appointed to your board who may not have been library users. So you have to make sure that they understand the complex job that you have and the complex role that the library plays in the community. And I think that's a really key role, because you're the one, back to Pat's theme of communication, you're the one who's going to make that connection, particularly between a board member who may not have had as much experience with the library in the past.
Yeah, and communication has been so important this last year as libraries have been closing, reopening, you know, cutting back services, adding other services in, whatever it is that we were all doing. I always think that even if people don't agree with what you're doing, if you communicate the reason behind it, they will be more inclined to come along with you. So it's really important that you communicate not only with your patrons, but with your trustees, because these people are out in the community. And if their friends and neighbors know they're on the library board, they're going to say, hey, why is it that only, you know, 5 people can come into the library at one time? You want to make sure that your trustees can answer that question.
Absolutely. And make sure they're up to date on all the wonderful things that the state library is giving them out under the CARES Act. Because there's a lot of new services that have come out because of the CARES funding. So make sure that they're aware of what those services are so they can also be community advocates about that.
Absolutely. Okay, not that any of you will ever have a problem with a library trustee, but in case you do, okay, usually problems arise when trustees don't understand what their role is. So it's really important that library trustees, especially brand new trustees who are just coming on board, understand what it is that they are responsible for. So there's a couple of resources that I have on here that are filled with information about trustees and what their role on the library board is. Our association, the New Jersey Library Trustee Association, New Jersey Library Association, the State Library, and the American Library Association, all of them have lots and lots and lots of information about library trustees and what their role is that you could share with your trustees. Some other problems that might come up, you know, we all hope that when an opening comes up on the library board, that the municipality appoints somebody who is really interested in the library, is a library advocate. Sometimes that happens and sometimes that doesn't. So you might find yourself with a trustee perhaps who has a conflict of interest or a personal agenda for getting onto the library board. That can be difficult to deal with. If it's a real conflict of interest, and Michael, I know you're on here, you might want to talk about what happens when you have a real conflict of interest. Somebody who's appointed to your board who should not be on your board. Is Michael on here or he left? No? Okay. No. Okay. So if there's really somebody who has a definite...
I'm here, Pat.
Okay, so Michael, if we really had somebody on the board who has a definite conflict of interest, they've been appointed to the board, maybe they work for the municipality, they work for a company that does, you know, the circulation system for the library, that person should obviously not be on the library board, correct?
Well, if they're a municipal employee, they shouldn't be on because, again, the doctrine of incompatibility of offices, that person has to serve two masters, the library and the mayor. There's case law on things like that, and I know there's an attorney general's opinion on that. When it comes to somebody that may have a business relationship with the library, if it's a narrow business relationship, they may be able to recuse themselves when that relationship comes up. I wouldn't like to see it, but the problem is the mayor is the appointing authority. And I would hope that somebody would go to the mayor and say, listen, mayor, you put this person in, there's a conflict. This isn't going to look good for you if something comes out of this that doesn't look right. So you may want to reconsider this. And of course, the best way to do that is if you can get wind of it before the appointment is actually made.
Yeah.
But I have seen instances where people work in a field of publishing, for example, and so they'll recuse themselves when it comes to voting on paying bills in that part of, you know, in something related to their job, but it doesn't impact at all on their ability to help set otherwise policy, evaluating the director, and things like that. So
Yeah.
it can be a little bit fact specific. Let me put it that way.
Okay. Yeah. So that might be something you have to address on an individual basis. I'm always leery of, not that it can't be done, but I'm always leery of people who have to recuse themselves from votes, because depending on what's going on with your board, that person constantly having to recuse themselves may prevent you from having a quorum, depending on, you know, what's going on. So, but again, this is where communication comes in. If you see somebody who has a conflict of interest, hopefully you can address that with the mayor before the person is appointed to the board. And if not, then I guess you just have to deal with it on a, you know, on a local level. Somebody could be appointed to the board who has a personal agenda. They've gotten themselves on there for whatever reason because they really like something that they want the library to do, or they dislike something. Again, that you have to deal with on a case-by-case basis. Something you could discuss with the board president, and maybe have the board president talk to that trustee about that. You may have a trustee who is never prepared for their meetings, or they don't come to the meeting. In your bylaws, there are state statutes about how many meetings a person can miss without an excuse, where you would have the right to go to the mayor and just say, we need somebody else appointed because this person is not coming. In your individual library board bylaws, you could have a clause about attendance at meetings, and you should stick to that. So if somebody is absent from your board meeting and it's an excused absence, they're sick, they're traveling on business, the board should vote to excuse that person from the meeting so that it's in the record. Okay. Inappropriate interactions with staff. This is always a big one. And Pat, I don't know if you want to chime on this one in. Remember I said before that the only employee that the library board is directly responsible for is the director. And that is the only person that the library board should be talking to about job performance or anything like that. So if the library trustees are in there and they're constantly interfering with the staff, or telling a staff to do this or not to do that, that is a definite problem. And the board should address that, because that is not the role of a trustee.
No, there's definitely should be a chain of command, and the staff should understand also that they can't break that. But I think Pat's right. You sort of start with the trustees to let them understand that it's inappropriate on their behalf to ask a staff member to sort of, well, how do you think it's going? Or what do you think? Or whatever. That's just, now I do know of libraries that perhaps union situations, they have a staff member who attends board meetings. That's quite appropriate as a communication tool. But I think it's something that the board president has to be very clear with, particularly with the trustees, saying that, you know, you don't interfere. You know, there is a chain of command. Most of these people have worked jobs before, so they understand a chain of command, and that at the library is no different. That the person who needs to be making the decisions, it's the director. There's a process. If there's something that a staff member is concerned about, there's a process by which they can go and either try to make a complaint, a process by which they can do that to eventually come to the board. But they should not be bypassing the director.
No, they should. The staff should not be coming to the trustees with a specific complaint.
Right.
Yeah, that has to go through.
That cannot. You should have a process set up. Right.
Right, exactly. Sometimes board members have, difficulty working with other people. That's a personality thing. I would address that as the director. If you're having an issue with one trustee, again, I would talk to the library board president and have the board president try to talk with that person and see if you can figure out what the problem is. Sometimes people are difficult because they don't understand. And again, I can't stress enough, it's really important for trustees to know what their role is and what their role is not, because that is other problems. Maybe you have a trustee who doesn't share the library's goals and the mission. They have a different idea of what that should be. The board has to have a united front. Once you have voted on a policy or you voted on a strategic plan, whatever it might be, even if the trustee doesn't agree with that, the majority has ruled and that is it. So they should not be undermining what the library board has decided. And again, this is, where personalities come into play, and it's always hard when you're dealing with personalities, but communication about this from the beginning is a good way to prevent this from becoming a problem.
Okay.
And the last one is interfering in the director's job. The library board hired you to be the director because they thought you were the person best equipped and best qualified to do this job. So they should not be interfering in your job. They should not be telling you what you should do. You should be telling them what you are doing. Now, again, you do report to the library board, so they have to approve certain things, but the day-to-day running of the library is the director's job. It is not the job of the Board of Trustees. So nobody should be telling you, oh, I think we should take all the 14-day books and change them to 21, or I think we should be doing this. That is not the role of a trustee. And they should not be doing that. They hired you to run the library, and that is your job. And sometimes that's awkward for you as the director to say to a trustee, but ultimately you have to find a nice way to say it because it's not their job. It's your job. That's why you're getting paid.
Right.
Right? And again, just kind of to wrap up, and then if we have any questions, or then if Pat wants to ask anything or say anything that I didn't say, it's really important that you have a good working partnership with your board. Okay, a good working partnership can make your job super easy. A bad partnership can make your job very, very difficult. Library trustees are appointed to work with you. And I stress that, with you. Okay, you're supposed to work together. You're advocates for the library. You're securing the funding that you need. You're developing policies that make the library a great resource in the community. And together you're solving problems that come up in the library that you're going to address together. And you're all on the same page. Ultimately, you want to make your library the best it could be. And if you're a new director, I say congratulations and good luck.
Okay.
Pat, you want to add anything? Or and then
my congratulations and good luck, but it's a wonderful career. I think you find as a leader, once you watch your staff develop, and as I said, I've watched some staffs just pivot during this crisis, and it's just been amazing how library staffs have kind of just taken this unfortunate situation and still made service to their community the priority. And you as the library director really set that tone. And I think that that is one of the things that you do best. And that is your role, setting the tone of how your staff communicates with the community. One of the other things that has happened, and I think one of the things that as advocates we can be proud about was the Library Construct and Bond Act, and that unfortunately, not as many projects could be funded because we had limited money, but I think it gave a new opportunity for boards and library directors to work together in terms of looking at the needs of their buildings, looking at the needs of their communities. I know that the new state librarian is having a listening session in the future. These are things that you, as a director, need to be participating actively in. Be active with the programs that the state library has, be active with the programs that NJLA has and the library network, because you are the ones who are going to be implementing those programs. So take advantage of all those CE opportunities, bring what you can back, allow your staff to have more CE opportunities. This is what will make a really great partnership. And with Pat's leadership at NJLTA, she's really done a lot to, I think, raise the visibility of that organization in the library world, being part of things such as the search committee for the new state librarian. So we really have a good partnership going, and we hope that we can continue that. But the linchpin in every community is the relationship between a library director and their board.
Yeah, absolutely. And again, in closing, don't make the assumption that your trustees know what it is they're supposed to do. If your library is not already a member of the New Jersey Library Trustee Association, our renewals are going out right now, so I'll give a little plug for that. Make sure that your trustees are members. That they can take advantage of the trainings that we offer. They can come to the workshops that we have so that they know what it is that they are supposed to do. Don't make the assumption that they know. Lots of times people say, oh, I'm appointed to the library board. I love the library. They don't understand that this is a real, it's not like the, the Clean Streets Committee that you might get appointed to on your town. This is an important committee. It's an important government office where you have real responsibility for a large chunk of taxpayer money, and that you have to abide by certain rules. So don't assume that your trustees know that. Through our organization and your knowledge as directors, you can make sure that they have what they need to be successful trustees. And that's it.
All
So
right.
Bob, I don't know if we have any questions. You're
We do.
manning the questions.
You do have some questions, and
I
I think
am
Bob
here.
will probably,
I
oh,
got it.
okay, good. Bob will read them. I just want to add one comment to something that Pat said earlier.
If it was
Which
wrong, it was you. If it was
It
right,
doesn't- it doesn't matter.
me.
I can't go wrong when
One of
I
us
just
said it.
say Pat.
The other.
Yeah, so you had said, talking about the micromanagement you know, with trustees and their director, and how frustrating that could be for the director, and how, you know, the director really needs to have that kind of conversation with the trustees, and that can really be difficult.
Mhm,
But there are things
absolutely.
to help you out there that are put out by ALA, and there's a nice chart that talks about the director's roles, the trustees' roles, and the Friends of the Library's roles, because that's a whole other thing when you're dealing with Friends of the Library.
Mhm.
And so there, I think I also have it up on our website under both the director's page, resource page, and the trustees resource page. So that chart, if you have a board that is really micromanaging you, and we do get a lot of phone calls from frustrated directors, so we do know that that's happening. You can give them this information to help you in having that conversation, so that you're just not coming at them. And, you know, you do have to have the difficult discussion, but you know, you've got backup material that you could bring with you that really is going to delineate what those roles are very easily. And you can give them out, you know, give them out in a pack to all of your board members. So hopefully that's a little bit of help for you. And that's all I wanted to say until Bob gets to the questions.
Yep. All right, first question from Linda McFadden. Are there any guidelines for the board as to what is in the contract with the director? Usually, how long is a contract?
That's interesting.
Yeah, I mean, I don't know that there's any, you know, there's any boilerplate contract. Some libraries don't even have a contract with their director. The director is just hired, and like any other employee, if the board is not pleased with what's happening, they go through the process of terminating the director. I don't know of any contract, I don't know. Of any form.
Go to Michael, but you know, I think this is a right to work state, so that people can be fired for, and he went over those kind of reasons that you could let somebody go. Civil service, if you're a civil service library, there's a very complex process by which a trustee would have to go through to see that a staff member is eliminated. So it's it is a very tricky thing. I don't know of any standard contract. Michael, do you have anything on that?
I've done a few of them. You can outline things like what the duties are, compensation, things like leave time, sick leave, vacation leave, things like that. That kind of stuff. You might include, you know, an evaluation process, a probationary period if it's not a civil service jurisdiction. If it's civil service, a term really doesn't matter, because as Pat said, with one exception, that's the Newark director, every other director of a public library that's in civil service is, you want to, if you're a director, you may want to have reasons for termination stated in the contract. If the library, the board of trustees may not, they may want to try and make it as much an at-will contract as they can. On the other hand, I've seen instances where there is no contract, especially in the civil service realm. But I've seen a contract in the civil service realm as well.
But have you had any that had a contract that had a specific length of time? Like, we're hiring this person for 3 years and then we'll renew them. I've never seen anything such as
That I
that.
haven't seen.
No.
Yeah,
That I
I think
haven't seen.
that's sort of her question, like, you know, because then a director's sort of like, kind of hanging out there, like, here's my 3-year review, and now I have to enter another contract. I think it goes back to Pat's thing, is you should have a yearly evaluation
Right.
that serves as that, but having something that has a specific length of time, I've never in a general director.
And even if you don't have a contract for your director, the board should make their expectations very clear to the director. What is it that the director is expected to do? Just like you would have a job description for any employee, you should have one for your director, and your director should know what that is. Usually directors are evaluated on not only their job performance, but the strategic plan. If you've set goals in your strategic plan, how well is the director, working towards those goals? All of those things, those expectations should be made clear to the director. And that's why it's so important to have a yearly review, because you're communicating to the director that, we expect you to do this, you're doing a great job doing this, or you're not doing so great a job, and we need you to work on that. Again, that word, communication, you have to make sure you can't hold somebody accountable for not doing something that they didn't know they were supposed to be doing.
But you also need to make sure that you have your salary and benefits looked at regularly, shall I say. I mean, for example, if you have been there for 10 years and they're only giving you 2 weeks vacation, maybe you want to go back and negotiate. I mean, so there has to be that kind of process too with your benefits, not just your evaluation, but what your salary and your benefits are. You are an employee and you are, you should have an expectation to be treated fairly and receive good benefits. That's part of what sort of the compromises, or not the compromise, the compact is between the board and the staff person in terms of making sure that you are also, because again, most times the staff, if they have a union contract or civil service, benefits are covered under that, where the director is excluded from that process. Okay.
Yep. All right, next question. Is it proper to have a trustee who is also involved, parentheses, the president, with an organization that independently raises funds for specific library projects? They do not hold an office or position on the library board.
Read that again. I didn't
say that again.
So basically there's a trustee. That trustee is the president of an organization which independently raises funds for specific library projects. That person is on the board, but is not an officer on the board. Is that okay?
So they're not a member of the Friends, or they're just raising money for a specific, I think we've all been that keep those roles as clear as possible. Somebody could be made a trustee and a member of the Friends, but no trustee should hold any office in any other kind of capacity, in my opinion, that's dealing with fundraising for the library. Anybody?
Michael?
Disagree?
Well,
So, Michael.
I'm pulling up the question so I can read it. A little confusing. The trustee who is also involved with the independently raised funds for library projects. If they're raising money and it's for the library and it's another organization, whatever it is, whether it's the Friends, a foundation, or something else, and it's going to benefit the library, I've seen trustees, library trustees, sit on a Friends and participate in a Friends organization. It sounds like it may be something akin to that based on the way I'm reading the question. So there I wouldn't see an issue. On the other hand, if it's somebody where he's raising money or she's raising money for a whole host of organizations, of one of which is the library, then it may call into question where the loyalty is.
There you go. All right, this is kind of just a statement, but the Willingboro Public Library says the township manager is on their board and they operate under the Faulkner Act. So if it's my understanding, the Faulkner Act, the township manager is the chief executive of a town that's under the Faulkner Act. Is that correct, Michael?
The Faulkner Act provides for many different types of forms of government. One of which is a council manager form of government.
I think that's what they're referring to.
Yeah, but my understanding is even under the Faulkner Act, the mayor is still the person who sits on the board ex officio. At least that's my experience. I'm not sure based on the statement what if there's a question there or not.
Yeah, I don't know if there's a
and the town manager both attending meetings, and are they both voting? Is that the issue?
I don't know. You know what? Let me allow the Willingboro Public Library to speak. If they would like to unmute
Okay.
themselves, they can perhaps give us some clarification.
Yes, good afternoon, everybody. Sandy Krantz.
Hey,
Hey, I was hearing you guys saying, no municipal employee should be on the board, but our township manager is our CFO and is an ex officio member of our board. Our mayor sits on the board, but not as a member. She is our liaison to township council, so she does not vote. But our township manager appointed one of his employees to sit in for him.
That's fine. So I
And
see
that
what we're
is-
talking about now. Under their form of government, they don't have the mayor ex officio. They have the township manager ex officio. So he's sitting as like the mayor would sit in a city. And so that's fine. And he has appointed as his alternate a township employee. That's the exception to the rule that says that municipal employees shouldn't be trustees. Because in this case, the alternate for the mayor is the mayor's alter ego. And so he's standing in for the mayor. And so he's going to be responsible to the mayor. And the fact that he's also responsible to the mayor as a township employee, I don't think creates the conflict that if the mayor or the township manager appointed that person to a regular term as a trustee, that I think would be different. But as the alternate from the mayor, or in this case, the township manager, I think that is fine.
Thank you.
yep. All right, that's okay. Cindy also said that our board has a fundraising committee. Are they allowed to raise funds for the library?
Michael?
The answer is yes, they can. You can solicit donations. And now how the fundraising is done, there are certain restrictions that a library as a public entity cannot do. For example, you can't run a raffle, but your friends could run a raffle. So it probably is a little better if the friends do it, because the friends can produce a 501c3 letter. You can't, in my experience, libraries don't apply for that because they're government entities. But the answer is, yeah, they can, and I've seen it done. But I think you're better if you have a friends group that does it.
But people can donate to your library, and it is tax exempt. I mean, you can donate to the library, but in New Jersey, you can't get any exemption from your state income tax, but you can from your federal income tax for donating to the library. So if you have a donation button up there, to my understanding, you can do that. And that is a tax exempt donation. But as Michael said, if you're going into something really big, you probably should need a different kind of fundraising. But you can do those things. But again, I think it goes back to his other presentation, if who controls the money when it's done. So if the board wants to control the money completely, and is that part, and what kind of expectation do you then raise with your municipality that you will always raise that kind of money? And that, I think, is an expectation that a board is difficult for a board to do, to say, like, the town's going to say, well, you raised $200,000 last year through fundraising, board, we expect you to do that this year. And that can be a very difficult expectation for a library board.
All right, last question, at least last question in the queue. Christine Hardigan asks, says, I have a contract that is reviewed by none other than Mr. Michael Cerrone. I would be happy to send to whoever would like to see it. I have a contract that is a multi-year like that, 3 years. So if anybody wants a copy of that, they can email Christine.
My recollection has been refreshed. That's right. They do a 3-year contract with his brother.
Yep.
There you go.
Thanks, Chris. Jog my memory.
And the queue is empty.
Okay.
So that means the program is done for the day.
We've
So,
answered every question.
yeah, I would like to thank all the presenters again, Michael, for hanging in there all day long and for your two wonderful presentations, Pat Tumulty, Pat Pavlak. It's always great to have you do this presentation. Bob, thanks for being there in the background so I don't have to worry about Zoom. And so thank you all the attendees for hanging in there for all of this time. Just want to remind you, same time, same place next week, next Wednesday at 9 o'clock. We're going to be starting again. It should be a slightly shorter day then. And we're going to have programs on strategic planning, library budgeting, and also working with staff, meaning you know, what to do when you have some issues or a staffer may possibly giving you a hard time about something. So there'll be some sticky situations that will be discussed there by none other than Cindy Cezak, who, you know, is like library director or emeritus extraordinaire. So we look forward to hearing from her. And if, I know Cindy's not listening, so she won't feel any pressure that I said that.
We're going to tell her though.
So I want to wish
Also-
everybody have a good day, and Bob,
Also, I'm
anything
going to
you
send
wanna add?
out, I'm sorry, I'm going to send out a reminder email at the beginning of next week with the correct URL this time.
All right.
And that's about it.
Okay, thanks,
All right,
everybody.
thanks, everyone.
Thanks, everybody.
Bye.
Take care.
Bye.
Bye.
All right.
See you
Pat,
next
see you
time.
later.